for DP IA initiation for fundamental meeting. It was pending for last October 2023. IFA. Next week, 7 or 9%.
9th of May.
Awesome.
Yesterday I filed it here. So I may be taken tomorrow. Yes. Apply.
Motion. Motion.
On item 24.
Hearing that the grade 2 stenographers of the subordinate group. Well, the advertisement notification came out at page 26.
On Shetty Commission.
Well, the page 26 is the notification. Shetty Commission, I have annexed, my lord. Well, the 26, your lordship will find stenographer grade 1 vacancies are 17. My lord, thereafter, the 5 years, either of grade 2 and grade 3 combined. The next page, my lord, your lordship will find at page 27. Candidates securing 30 or more marks out of 50 will be eligible for promotion to grade 1. So 30 marks is the cutoff. My lord, thereafter, my lord, the eligible candidate at page 33, there are total 135. In 135, 30 was from grade 2 and balance are from grade 3. Page 33, it's the eligible candidate. And page 38, your lordship will find the marks of 10. My number is at page 46 and 89. I have crossed the bar of 30. Serial number 46 and my lord 89. Now, my lord, the list that has come out at page 44 and 89, serial number 89. Out of this 116, 17, 25% were from grade 2. 25 have qualified and balance are
It is seniority come merit.
well, nothing has been laid down. But after this, why they prohibited from following the Shetty Commission? What prohibited them? When, my lord, grade 2 and number of vacancies, the grade 2 are more than the qualified, more than the number of vacancies. What prohibited them from taking into consideration the Shetty Commission? Because grade 2, there were 25, 17 vacancies were there, all qualified for that post. There were more than 30. Now, in the list that has come out, you'll also will find that page 44, there are 5 numbers which are who are grade 2 and balance 12 are from grade 3. Page 44. And the Shetty Commission, my lord, is at page 48. Starts at page 47. I have taken the extract and give it here. And the judgment of the Supreme Court at page 50. Starts at page 49. Page 48. Grade 3 is direct. Grade 2, 50% promotion, 50% direct recruitment. Grade 1, direct promotion from grade 2. Page 48. And the Supreme Court judgment, page 50.
Now you have challenged the relaxation.
This relaxation, but after the list has come out for 17, what prohibited them from taking into consideration the Shetty Commission? Because that one-time measure, because I can understand if number of persons are less than the number of vacancies. But here, 25% has qualified. In the 116 candidates who got more marks, and 25 qualified for that in the of the grade 2. But they have not taken consideration of the grade 2. They have taken merit wise. But what was the requirement for merit wise? Nowhere it was laid down. And there are some candidates, grade 2, who are working more than 13, 14 years, and a 6-year candidate who has worked for 6 years in grade 3. They have been promoted by. And my lord, at page 52, your lordship will find earlier, my lord, that committee, the centralized recruitment of officer staff and subordinate judiciary, my lord, at page 52, my lord, these are all taken for a one-time measure, and at page 53, last paragraph, the reasons shown earlier this was in the year 2013, if I'm not wrong, my lord. Page 53, the reasons shown for a one-time measure. Page 53, last paragraph. In view of creation of new post and non-availability of sufficient number of stenographers.
Now, why you are challenging their appointments of who are stenographer grade 2?
Well, not because the whole list I have challenged, so that is why the decision. These are all, they have also been given on the merit wise. But posting it till now has not been provided to anyone.
Yes, Mr. Nath. That's what is the basis on which you have promoted?
So I have got this copy right now. Just available. It was filed yesterday. I need to take it.
Mistake?
Stay may not be granted.
Absolutely. No,
The reason why I'm saying.
no. Because last time I did not do it only on the ground that we had been challenged. Now, this time, there was no good reason as to why you have done it. You can't keep on when you have the pool.
You know,
You have the pool of, you had how many vacancies? 17. You had 28 people from grade 3.
25.
25 people from grade 2. Then on what basis you are bringing the grade 3 up? If you are having it on seniority come merit, it is okay. But if it is not seniority come merit, yeah. Now these people have already crossed 30.
no,
It
this
is
25
30. Then 30 out of 50. Then they are entitled to as per grade 1. Can you see your advertisement itself?
Yes, ma'am.
Candidates securing 30 or more marks out of 50 will be eligible to promotion of grade 1. Now both the petitioners have got more than 30. It is your own document.
Yes.
And then
Out of eligible for promotion to grade 1.
Then
And it's 25 in number. But can it be taken up?
you state today.
But I just, I,
Don't leave it there.
I could not even.
It are required to be state because you can't keep on because the
They are
standard
challenging an application of.
every time it cannot be a one-time measure business.
Yeah.
Time it was a one-time measure. He did not challenge it properly. But this time he has challenged it. And those documents which we are showing it, I've seen it
Earlier.
earlier, not
Yes.
earlier, the recent one also. When I put that question to you, how you are doing it, you are then also putting it that if it is more than 30. Now he has got this 30, both of them. Then why you are not taking them? Then what is the further consideration you are taking? I will have it next week. We'll have it next week.
38. Yes. Gulzar Hussain Golpi.
Huh?
The petitioner.
Is that a serial number 40
6 and 89.
and
One
18?
second.
46 got 43 something.
One is, my lord, 46, he got 44.37, page 40. Page 40. Serial number 46. And 89, he got 38.
You cannot ignore all these grateful, unless you have something. Sorry.
So far as I
Notice.
remember, my lord, so far as I remember, the selection was in pursuance to a speed test. Speed test is a must. 30 beyond, you are eligible. Below 30, you are out of the game. Rest will be based on the performance in the speed test. So, projection that the petitioner has been made, the moment I get the key, I am entitled to be.
No, Mr. We will stay this in the next day.
And the
So notice-
petition they have challenged the December 2023. Another
He has also select the select list.
challenge the select list.
Select
But
list
this
only happened
criteria
there.
that has been projected,
Select list is of 2025.
select list of 25.
22nd, page 44.
But the prayer number one, the notification,
One prayer may be old, that doesn't mean that word, because that is the culmination of that.
kindly appreciate this,
Oh, issue notice.
this 13 months.
When you can
business
file your affidavit. When you can file your affidavit.
and
All over, sir. But you are going to get it only from the centralized only people. So you have to file your affidavit, file your affidavit. To notice, making it returnable when? 8, 15, 22nd, which one?
22nd.
Issue notice making it returnable on 22nd of May 2025. Steps be taken, Mr. H.K. Das appears on behalf of the respondent number 1 and 2, Mr. T.R. Puroi appears on behalf of the respondent number 3. So as regards the, taking into account the respondent numbers 1, 2, and 3 are duly represented, extra copies of the petition be served upon them during the course of the day. As regards the respondent numbers 4 to 20, extra copies of the petition be served upon Mr. H.K. Das so that he can effect service upon the said respondents. And submit a report and registry. And the registry of this court shall submit a report as regards effecting of service upon the respondent number 4 to 20 before the next stage. The petitioner hearing who are great, admittedly grateful stenographers. I was saying the advertisement issued on 9/12/2024, as well as the notification dated 22/4/2025. On the ground that the said advertisement as well as the notification is not in consonance with the SETI Commission's report. The report which have been accepted by the Supreme Court as far back as of Seven 10/2009. Mr. P.K. Roy Chaudhary, the learned counsel, appearing on behalf of the petitioner, further submits that there is also a committee formed by the Guwahati High Court, committee formed by the Chief Justice, by the Honorable Chief Justice of the Guwahati High Court for the purpose of accepting the SETI Commission's report recommendations. However, it is seen that on each and every occasion, the committee so formed for centralized recruitment of officers and staff of subordinate judiciary and all benches of the High Court have made a one-time relaxation which clearly amounts to a violation of the order passed by the Supreme Court accepting the SETI Commission's report recommendation. The Learned Council, drawing the attention of this recommendation of the SETI Commission, submitted that for the purpose of promotion to the post of stenographer grade 1, it has to be by promotion, it has to be from the Peter cadre that is a stenographer grade 2. The Learned Council further drew the attention of this court to the report of the report of the joint committees of centralized recruitment of officers and staff of subordinate judiciary and all benches of the High Court, as well as the SETI Commission's recommendation on revision of pay scale, etc. Dated, what is the date? 10/11/2016, wherein as a one-time measure, such relaxation was granted. The Learned Council, appearing on behalf of the petitioner, further submits that every time there cannot be a one-time relaxation. The Learned Council for the petitioner further give the attention of this court that when there were enough candidates in the pool of stenographer grade 2, the question of deviating from the SETI Commission's recommendation amounts to a malice in law for which the entire selection proceedings is required to be interfered with. This court have duly perused the materials on record and have also taken note of the recommendation made by the Joint Committee dated 10/11/2016. From the recommendation made by the Joint Committee, it is apparent that the Guwahati High Court have duly accepted the SETI Commission's report, and for that purpose, the said committee have been formed for the purpose of the Guwahati High Court have duly accepted the SETI Commission's report. This court further has taken note of that, in spite of there are officers available in the stenographer grade 2, there has been a relaxation made this time also. And there is no manner and have been it is also seen that from the test, from the rank-wise mark sheets of the stenographers, the petitioner, both the petitioners have crossed the benchmark of 30 marks out of 50. Considering the above, it is the opinion of this court that till the respondents bring on record their stand and the matter is decided in the entirety, the select list dated
2nd April.
22
Page 44.
22/4/2025. Issued by the Register Administration come in charge centralized recruitment. Is required to the state. Accordingly, the improved notification dated 22/4/2025, as well as all further further notifications issued shall remain state till the next time. The respondents shall bring on record their stand by filing their affidavits on or before 16th of May. 16th of May, the petitioner would be at liberty to file the reply by 21st of May.
Item one, the daily list, voters, the packaging. Advertisement was issued for post of driver that your lawsuit get been received. Serial number 2. Now, criteria is page 20, madam. Point 10 and 11.
Huh?
10, 20.
Applying for a post of shall have to appear in a driving test to be conducted by
Candidate applying for the post of driver shall have to appear in driving test be conducted by the district transport officer, Southwest and Viva boys. So Viva boys, what marks they have given, they have not said so. But ultimately, madam, when the result was out, madam, before that, may I just point out how the Guwahati High Court advertises, page 24.
8,
24.
22.
24. It starts from page 23.
Written examination by mark.
Then driving
Injunction
test,
and the same shall contain
interview.
questions on road sign recognition, 20 marks and general knowledge.
and 40 marks,
I think
40 marks and 20 marks.
Because also 20 marks. And
These are the criteria for driver. Respect of Guwahati High Court.
with 100,
Yes, out of it. Now, what they have done is page 29. Page 29, these are the marks allotted. Petitioner is at serial number 8. And respondent, private respondent,
yes, Mr. Das, how have you increased?
40% marks they have given for Viva boys.
How have you increased from this page 20?
24 is not, 24 is not this. High Court. Page 24 is not this. Not this, I'm just showing an example that how. This equipment is page 20. 20. That option. 20 only says Viva boys, but it doesn't say how much marks and all.
Do you have the records?
But now you got to say 29, page 29. How the marks were allotted. The marks obtained in driving test for in respect of the petitioner, your lordship, serial number 8. He got 45 marks. In traffic signal, he got 25 marks. And in Viva, 20. And whereas the private respondent at serial number 3, he got driving test, it was conducted by DTO, madam. He got 30. Then thereafter, he got 10 in traffic signal. And in Viva boys, he has been given 55 marks. And I have calculated the percentage. Percentage showed, my lord, the Viva boys test, they have given 37.5%. For traffic signal, 18.75. And for driving, 43.70. This is out of 160. Now, the apex court judgment, your lordship knows, my lord, if the marks are not allotted for Viva voice test properly, my lord, it amounts to changing the rule of the game. I'll give the para 6.
How many cases? When the Viva was test, you cannot have 43.37.56. And you cannot, on what basis when the 55 marks has been given to the five. Many cases have been discussed there. They think the Viva was test that cannot be more than 20. 20 is reasonable. 37.4%, that also allotting 55 marks.
So this driving test, 70 was earmarked. Out of 70, the selected candidate was given 30. And for 45, petitioner was given 45. So for a mark in the Viva question was total mark was 60. Out of that, we got 55 and 20 was given.
What is the total marks?
160.
How did you find out 112?
I find in my affidavit.
Let us see your.
Yes, in page 29 also, my lord will find. In page 29 of the repetition, total mark in the lordship will get 160.
Where?
In the extreme right column, my lord, top. Total marks out of 160.
Page 29.
Page 29.
To 160.
70, 30 and 60. So the
70, 30. 70, 30 and 60.
Yes. So the three-member selection committee, my lord, conducted the interview, my lord, judged the various traits and my lord the qualities and derived conclusion.
Let us see the selection. They have, because it was not mentioned anywhere. It was not mentioned in your advertisement what will be the marks.
So, yes, it
So
says
we will
that,
have a Vivavosa test, there will be a driving test, that is has been mentioned.
in fact, if I just explain,
So it will be there in the selection committee doing it prior to that.
yes, it's
Show me that. No, records.
records me that I have been.
Records
I
me.
get the record.
If there's no record, we'll drop presumption.
There has to be a record.
Then?
But I'll get the record.
When you get the records, 2 o'clock.
So it's from South Salmara.
So what? You knew it. Further, the
Yes, sir.
initial copy of the will be survey, who has applied the service upon to the respondent to the respondent teach. It is to further survey and initial copy of the. So produce the records, this is not done. You have. And also, why have you put 60 marks out of 160 for? Because of that. How, what will be the percentage? 60 out of 160?
We calculated it comes about 37.5%.
So there is no fixed notification as to how many marks.
Not necessarily, there are Supreme Court judgments for that. Many judgments.
Marks they have taken for horror voice. And what kind of reflecting the marks itself kind of amounts to violation.
Thirty-seven
Who
point three.
mandated that in the advertisement itself, the marks has to be, you know, the category of marks or the heading has to be given in the advertisement. There is no.
In a recent judgment of the Supreme Court, Justice Dipankar Doctor has also remarked on this. I have such marks, 37.5%.
In that event, Miller, the petitioner ought to have challenged the advertisement. In that event,
Not necessary. He thought that he has been done here appropriately. You have not mentioned it. He thought that it will be done.
That-
That as per the law of the land, it says that there should not be more than 25%. That's the law of the land. If you have done something, then on the basis of it, it becomes arbitrary. It is not required for him to challenge it. He may not get it. Petitioner may not get it. The selection to go for fresh. He may not get it. But how do you give 55 out of 60? Oh, good.
the committee, there is no malafide against level against the committee or bias. But the committee may not sits together and we have to, the committee sits
A
together.
person who gets 20 and 10, 30 and 10, 30 and 10, person who gets 30 out of 70, which is less than 40%. And 10 out of 30, which is again 50%. But gets 95 out of 100 in rewards.
For driver, because for
So good.
driver,
So
not
good.
only the driving skill, but as a driver of a judge.
Then why you are having an OMR for the Guwahati High Court? High Court is wrong.
Right.
Is it a cross?
Recruiting
Is it a
agencies
case
are
of
following
cross illegality, Mr. Das? The cross of
I think
gross
it's
illegality.
following a different
This
procedure.
court cannot allow this type of. To me, the records should have been there.
But, your lordship is correct.
How on earth a person fixes 160? Why is it 160? I don't understand.
I also don't understand why 160, but what happened,
Only it should be
I just
100.
explained. But
Why is it so difficult for them that they want to make it 160?
Milord, if
Or
I,
is it done subsequently?
no, Milord, what
It
happened?
must be Mr. Das, actually it must have been 70 was there and 30 was here. That must have been there. Okay, 30 must be 40, 20 and 30. It must have been there. Or 20 must have been there, or 40, 20, 20. 40, 40, 20, something like that. Then later on found that this person has got less in first two categories. So made it 160. Auto,
70, 30, 60.
But actually, what happened in
out of where
And
you find
ultimately-
160, what is
Ultimately,
the parameter on which you are having
if
160?
CGM in the affidavit says, oh no, he is the driver of 108. Now they are coming up with a different logic. Then he is the driver of 108, so he is very rough driving. If you insurance contracted the case, he has given the marks. Now they are questioning earlier experience 108. These are not good.
No. Viva was say, where is the question of Mr. Kalpil? Mr. Das? Where is the question of in Viva was driving?
In the affidavit is said.
Milord, if I,
Driving will be in the driving test.
no, Milord, what happened here?
Then
Milord,
the
we- Milord, may I just explain?
basic foundation is wrong.
May I just explain? Milord, what happened, Milord? We send the matter to the NBI, asking him to you conduct the driving test. Now, what the NBI had done, Milord, he puts up two columns, driving test and signal test. That was not said by us. So he puts up two columns giving 70-30 mark and he gave mark. 60 is our part. Since he gave 70-30, but we have to give some mark in Viva Bose. So that's how he came to 160. We did not fix it 70-30 for, Milord,
So
in
that
fact,
means,
my
are you,
affidavit says,
Mr. Das, are you therefore admitting that at the time when you held the selection proceeding, you did not have formulate the criteria? That appears to be
this 70
doesn't make the submission. You are admitting by yourself that you did not fix the criteria under which the selection is to be carried out.
not this, we fix the criteria that driving test and Viva Bose. But when
When you ask the MPI to do it, you did tell him what is the parameters. We didn't. So that means you did not formulate the parameters on which the selection is to be made.
our stand also in that.
First of all, in the affidavit, advertisement, there is nothing mentioned.
Yes.
Obvious. Then you can very well go ahead and formulate the selection proceedings by saying that these are the criteria we are taking. So that means you did not take into account the criteria. On the basis thereof, it has to go.
Some reports I have. You will kindly have a look. will also correlate this with para 8 of my evidence.
What is this 22/3/2023?
Perhaps this was postponing the date of interview.
Then you had only, where does if this is the resolution, then where you are have, what is, you are going to only have 60 marks,
For Viva also.
nothing else.
Yes.
Then where is the question of others? This resolution goes very much against your very advertisement.
Advertisement says Viva also and driving test.
Understood? Where is the driving test then?
So driving test was held, but
No, I'm asking you. Here there is nothing. Kindly see
in the
this.
resolution.
So you
Perhaps-
have had it.
Perhaps this is a subsequent, the driving test was held earlier. I'm sorry.
You see, 25/2022 is the advertisement.
Yes,
Okay.
yes.
Now this is the advertisement. Then therefore I said the resolution of 23 is relevant. 22/2023, which is being mentioned out there, is relevant.
Regarding postponing of the interview.
It's,
Yes.
so therefore, either that resolution must have stated how you are going to do it.
We just check the records and I just played. Because what happened, my instructions is that, there were litigations and there was a complaint in the
Obviously,
vigilance
there will
also.
be litigation. This type of
Earlier,
things were doing.
For other
Eligible
posts. not for
candidates
this
have to appear for Viva also.
Accept.
Candidates applying for the postal shall have to appear in a driving test to be conducted by the Imams of Salma and Viva also. So these are the two bases.
Yes.
Either the driving test and Viva also.
For
Then where does the third criteria come into picture?
the third criteria regarding
Signal.
signal test was developed by the MBI himself. It was part of our affidavit also, para 8 we have said. It was developed by himself, the third criteria, and he has sent the mark to the concerned, the selection board member, and thereafter
Okay,
the
produce the records. Court is not satisfied with all this.
fine. But this 30 mark in signal test, that was never suggested by the selection board or the appointing
It is outside the scope.
outside the school. So
Outside
that
the
is,
scope.
that's why in para 8 of our affidavit, we have clarified that as well.
So the moment we remove 25 from the petitioner and 10 from you,
Yes,
the entire thing goes for a toss.
perhaps removal of this, at this stage, removal of a column may not be proper. That's all.
Removal, the entire thing has to be set aside. Go for a fresh solution.
That can be done.
Not the way.
I also, the record that I have seen, Milord, I also find that this two columns, bringing two columns is beyond the purview of the selection process. The MBI could not have bring two separate columns.
And why on earth did they ask for 60 marks for Viva say?
60 mark is
No,
fine.
no, no,
Milord.
no. It is not fine because of the fact
It
that
has happened.
recently, this is Dipankar Gupta, Dr. has stated out there in one of the judgments
Yes.
that India is a place where people are fighting for their jobs. That is, I think, in the case of Bihar. And whenever the marks is on a higher side for interview, there is always a doubt that if there might, in the case of nepotism. The recent judgment,
I have gone through, Milord. I don't remember the name, Milord, but it's there. That has been held. But if I see,
because when you see the marks of the person, Mr. Khan's client, he's nowhere in the picture.
in the driving test,
In the driving test or whatever test the MBA had done, he's nowhere in the picture. He comes even below, let us see. That person gets 40 out of 100. Okay. Then number one gets 45. Number two gets 40. Number three gets 40. Number four gets 50. Number five gets 40. Number six gets 35. 45. Number seven gets 45.
45,
Number eight gets
70.
60, 70. Number nine gets 40. Here the petitioner, the response number 6 is nowhere in the picture. So how
All
do
are
you,
no, all are nowhere in the picture. Going by the marks scored by the petitioner in column 1 and 2.
1 and 2, nobody is in the picture.
Nobody in the
Now
picture.
all of us are there. So how do you take care of it? If you have a 30 marks, then also you have to give him minimum 10 marks to this. He's already 70. Yours is 40. So it does not happen. You see,
Not possible.
response
Yes.
number 6, if it is just taken as 40,
Yes.
it can, if the petitioner gets 0 also in the paper say, then also he is not equal. It will be equal if he gets 30 out of 30, 100 marks.
Yes, in the sense of-
So what he does to make it 60, so you make him 55. Then exactly he gets 95 and he giving him 60, 20.
60 mark criteria is not at the time of this thing. It was given earlier. And Milord, the resolution says we received the remarks in a seal cover. Till the time, this was held, this, selection was held, we did not know the marks of the,
So you decided only after getting the to have 60.
no,
Yes, yes.
why I'm saying,
See this?
I'll just check.
Take a
Yes,
word.
yes.
No, word, Jackson.
Milord,
In a-
what happened in this matter, Milord? What happened? There was a complaint with regard to selection for the post of peon. There was a Milord inquiry by the vigilance of Guwahati High Court. Then, Milord, all the records were sent along with this marks given by
I think
the.
this is a good case for going for an inquiry against these members also. What is wrong with this member? Having it 60 after that. He did.
Yes.
After getting all
After
this
receiving
thing, then
all
he
the
did
original
decide 60.
documents relating to recruitment so and so, today the seat envelope relating to driving skill submitted by PO and
So
the
after,
PO South
after getting it, they decide 60.
and according to board, just to continue the recruitment process, so and so, it was postponed. And so hence the board decided to conduct interview for Bharat within 60 marks, in which member will be awarded 20 marks. Yes. The honorable chairman accordingly requested to publish the same select list and so official reply directly. Yes.
After
What is
getting it, after opening it, now they realize, oh, you cannot get him out. Unless and unless we do one thing, we make this.
No, 43 mark is given to serial number 1 also, Perhaps this view expressed by your lordship. Serial number 1, he was also given 43 marks, more
No,
marks
he-
than the petitioner.
Mr. Serial number one is nowhere in the picture.
So if we compare the
There's
marks,
only you can see, he's only 45.
I understand.
He's only 45. He's nowhere in the picture. There has to be something shown.
If
And in the Viva say, the driving test is okay. Driving test is conducted by the MBI. Okay, what I mean. In the Viva say, your members come up and say that he drives rough. Isn't it the most funniest thing when the CCN
it
like
doesn't, no, it doesn't say so.
you know, isn't it says
No,
108
affidavit says.
in the
In
affidavit?
the affidavit, it is the stand that being a driver of a judge. What they say is that 108 driving is different than official driving. 108 driving for
Tell
ambulance.
me whether this person concerned, the response number 6 is in any way employment in temporary basis anywhere.
Yes,
the-
yes.
Yeah.
He was driving. No, not in the.
This is how it is.
official.
It is exactly the case when I was taking up the other matter that day, no? Where the officer concerned takes him everywhere. Wherever he is appointed, takes him everywhere. And one fine day, the officer gives him the substantive appointment.
That is not the case here.
Absolutely, this is the case.
I'm just checking.
Hello, what do we do? We allow the petition? Or you want to produce the record?
So far as
If
my
records,
submission
then
is
when
concerned-
we go for a CBA inquiry.
So far as my submission is concerned, there is an inherent flaw in the recruitment process with regard to the additional column of marks created by the MBI employee. That is our specific stand in para 8 of the affidavit also.
No. The serious flaw is after getting the marks from the FBI, you have gone for a viva voce of 60. That is the serious flaw. Or the serious flaw is at the time when you decided what are the marks to be allotted, you did not decide what is the marks to be allotted for driving test and viva voce. This is the serious flaw.
At the time of advertising,
Absolutely, that is the serious.
but nobody has challenged that aspect.
How will somebody challenge you do it behind closed doors? How will they know? It is apparent now. You don't mention anywhere at paragraph number 10 and 11 of your recruitment as to how you are going to place the order, the marks will be given. You don't mention anywhere. Okay. If you don't mention, the select committee can very well do it. It is normally to be done prior to the selection. This is the mode. Prior to the selection, they do it so that it becomes more fair, which you don't do it. Now here you do it subsequently. Now subsequently you may have done or may not have done. And if you have done, later on you again add another 60. So everything is bad. You bring the records, I think this is a case for bringing the records and placing it so that
Yes.
this court can have direct
Have an idea about-
vigilance inquiry upon these officers who have become the selection committee. As to how these type of things can happen in the judiciary. Are these people not aware what is Article 14 or 16? Mr. Das?
Yes.
It seems Article 14 and 16 is only there in the High Court. And for me, it is only on Thursday. Other days is civil bench one. So for like these judicial officers, I also don't know what is Article 15 and 16. What do you want?
Look, may I just raise the records? Perhaps there will be problem.
I think this is a case of vigilance inquiry.
Take a call on this.
No, I think it's required. And also, where was this response number 6 working?
Look, I found somewhere, I'm just.
Now, if the respondent number 6 was working out there in the High Court, in that establishment of the CGM, then it becomes much more apparent what you are doing.
Yes,
Then I think it's goes for a vigilance inquiry as to how selections are being. One has to be strict.
yes, yes.
Yes. This court. As Mr. With regards to learned senior counsel assisted by students who are appearing on behalf of the petitioner. I've also heard Mr. H. K. Das, the learned standing counsel of the court, and Mr. M, who appears on behalf of the respondent number 6. The petitioner hearing who applied for the post of a driver in the establishment of the Chief Judicial Magistrate South Salman, Mankasa, pursuant to an advertisement dated 25/2022, have assailed the notification dated 5/12/2024, whereby the respondent number 6 was appointed to the post of the driver. Mr. Vidit Das, the learned senior counsel, drew the attention of the court to the advertisement dated 25/2022, and more particularly to clause 10 and 11, and submitted that for the purpose of selection to the post of the driver, the person concerned, the candidate concerned has to appear in a driving test to be conducted by the District Transport Authority, South Salmara, Mankasar, and there would be a viva voce test. Submitted that in the advertisement, there is no mention as to how much marks would be awarded for both the tests. The learned senior counsel submitted that it is an established principle of law, as has been held by the Supreme Court in the case of Vishnu Biswas versus Union of India, reported in 2014 4 SCR 625, that marks allotted for oral interview in grade 4 post where it beyond 25% makes the way selection proceedings doubtful and comes within the midchief of Article 14 and Article 16 of the Constitution. The learned senior counsel further drew the attention of the court and submitted that there is no basis also assigned as to why the total marks have been awarded as 160, except 160, except on the ground to accommodate the respondent number 6, who did not fare well in the driving test as well as the marks obtained in the traffic signal test. This court also heard Mr. H. K. Das, the learned standing counsel of the Guwahati High Court, who submitted that as would appear from the materials available on with him. Initially, the marks which was allotted was 100 or 100. However, subsequently upon receipt of the report submitted by the MBI, by the District Transport Authority, a resolution was adopted on 18/11/2024 that 60 marks should be allotted for Viva Voce.
It's member 20.
60 marks
Yes,
should be
yes,
allotted
yes.
for Viva Voce. He, however, submitted that the records, if called for, would show the correction, was taking into account that the matter has been substantially heard. This court fixes the matter again on 8th of May 2025, on which date Mr. H.K. Das shall without fail produce the records of the selection held on selection held in pursuant to the advertisement dated 25/2022. List accordingly. The interim order passed earlier shall continue to the disposal of the petition in view of the said order. With the disposal of the next. This court, by the detailed order passed in the accompanying writ petition, have extended the interim order passed till the disposal of the instant writ petition for the reasons already stated therein. Accordingly, the instant petition so filed, instant applications so filed from vacation or modification of the interim order stands dismissed.
What's the rest part?
And
Related party.
I will not require all the orders only come to me.
The way was it?
We'll finish it up and
I
I'll
also
get
try
to
to get you the information that his antecedents, the respondent number 6 is antecedents.
get it. No, why I'm not asking only for the driver, no? I asked all the selection pursuant to the advertising, which includes all the posts.
Beyond processor and everything.
Because then it will be clear why in other posts it is 100 and here 160.
Yes, yes. In fact, because there will be inquiry also with regard to the other post. And pursuant to that inquiry, the entire record was sent to the High Court for holding an inquiry.
Same thing is
I
something.
read it space.
Once it is, we need to make these things.
Yes, yes.
All right, it's an item two.
Take on the ID. Yes, what is this?
This is with regards to increment.
Huh?
Increment. So petitioner is and
You have filed reply?
Yes.
Huh? You have filed. You have to file reply. Have you filed it?
no,
You are not filing it.
cannot find it.
Now, what is your case?
So the petitioner is entitled to one annual increment.
Hmm?
Annual increment.
Why it was not given?
It was not given because I was promoted to the next post. So it was not given, not because. So you may kindly see the impugn order. Impugn order at page 18. This clearly written here. This is the order which was filed. third paragraph. Relevant code.
Yes. What is your case?
And the respondent number 3 and 4 filed affidavit in opposition. In their affidavit in opposition at page 4, paragraph 12, they have
Number 3 and 4.
3 and 4. It's affidavit filed by respondent number 3 and 4. It is dated 25.
I have a
Right.
respondent number 2 of it.
Yes, two affidavit, one by department.
It records from 19.
It was filed on 25th of July, 2019.
I have only affidavit in opposition and 11. No, there is no affidavit of 27(3).
25th July 2029. This is the
Huh?
affidavit
2000?
19.
Affidavit 5.
Yes, yes, it was the affidavit.
There is no affidavit out here.
Affidavit,
Are you in this case? Dipumoni Kolita.
yes.
Here we have only 3 affidavits. And that I have. I don't have the affidavit of respondent number 3 and 4.
3 and 4.
Who is appearing for 3 and 4?
The time affidavit.
Respondent number 2 has filed an affidavit. 3 and 4 has not filed an affidavit.
3 and 4.
Now the question is, you want to go on a higher payment.
Yes. Right.
Okay.
The whole contention, I mean, as stated by the respondent, admitted, except one. Thing is that I was not afforded the opportunity to exercise my option as provided in the
But
fundamental.
you, in your,
Yes.
you by yourself say that you did not exercise.
I did not exercise because I could not exercise just because necessary forms and necessary forms were not given to me. And my bill was prepared by the head assistant of the establishment without any information. Because I was
It is
newly
required
tra-
to inform you.
Yes, sir. I newly joined the post. Thereafter, I started working in the establishment. Then in the next day, period, my salary bill was prepared by the head assistant. And I was not in. So head assistant on his own volition, he said that, yes, I am ready to, take the new enhanced, scale. In fact, I was not given the opportunity to exercise my option. If
I
your
can see
lordship,
the Rule 11. That is the question, no?
Yes, yes, 211. Rule
Rule
11.
11 is where? Where do I get the rule 11?
Arrow.
Where is it?
It is in the additional affidavit, madam. In my additional affidavit, I have an
Fixed traveling allowance. Rule 11 is what?
That
Which page?
page 34 of my additional affidavit.
Page 34.
Of the additional affidavit, this is part of PD.
34, no. Starts from 31, 32,
And
33,
the rule,
34, yes.
yes, 34. Note 1, in case the government, last part, of secretary, fourth paragraph. In case the government employees opts to get his pay fixed from his date of next increment, then on the date of promotion, pay pen shall continue unchanged, but rate pay of the higher post shall be granted. Further refixation shall be done on the date his next increment, 1st of July. On the day such a government employee shall be granted two increments, one annual increment and the second on account of promotion. While computing these two increments, basic pay prior to the date of promotion and the grade pay corresponding to such pay in the pay band shall be taken into account. After allowing such increment, grade pay of the higher post and scale shall be allowed. In case government employee opts to get his pay fixed in the higher scale from the date of his promotion, in case, my God, only in case when I exercise my option, then only he shall get his first increment in the higher grade on the next July. In my case, that this opportunity was not afforded to me.
So you say it is only when you opt,
Yes, option is must.
then only they can fix it in the higher grade in the.
Either way, either higher or lower,
But then only note 2 comes.
not to come.
You opt.
If I and
Otherwise, note 1. Here is note 1 is also opt.
option is must. I
Then
should be given opportunity to exercise my option. Without giving according me that opportunity, the employer cannot, raise my bill, salary. That is what they did in this particular case.
but
And
you are to opt.
I am told that opportunity was
But you
not
have
given
not
to me.
opted.
My lord, that opportunity was not given.
It is here you say in case the government employee opts.
Oh, but
Where is
unless
the
and
question of giving you the opportunity? It is your volition.
because on my lord, one form is required that should be provided to me.
No, where is it? Where is it mentioned that that form is required to be given?
My lord, in my additional affidavit, I have stated so.
Your affidavit saying you will not do it, but it has to be on the basis of some memorandum, something.
Yes, in FR 23, it is a
This
memorandum.
memorandum dated 27th year, the relevant portion.
Yes.
It is further reiterated that in order to enable the officials to exercise the option within the time prescribed, the option clause for pay fixation or promotion with effect from the date of promotion can invariably be incorporated in the promotion of the appointment order so that there are cases today, there is a case of delay in exercising the option due to administrative lapse.
Yes,
So if this aspect was not there in your order,
this was not good. This was totally overlooked. And if we see the FR 23, there also the condition of exercising the option is must.
the term is mixed. This could not be Yes, Mr. Das, what do you say?
So, allocable grounds, this rule doesn't provide that can opt for fixation of this pay from the date of next increment or immediately.
From the date of?
Next, DNI, it says, suppose, my lord, his increment is due on July. He got the promotion in,
Yes,
October.
let us take it by way of an example.
Yes.
I'm a bench one judge. This person was an LDA,
Yes,
so
he got,
he was entitled for his increment from 1st of July 2011.
yes,
2011. Now he gets promoted
yes.
with effect from
If I, April, 2nd January, within 2nd January and 30th June. He got promoted on, uh, 1 second. 5/2013.
2013. But it is effective from 2/5/2013 or from the date of his joining.
From 2/5/2013, right? Order dated 25/4/2013. And he joined on 2/5/2013.
Okay.
Yes.
Then
Then this period comes in between 2nd January and 30th June. And 30th of June 2013.
8th of June 2013. Huh?
Yes, my lord.
Then
Rule 11C, note 2 provides that he will be eligible for increment with effect from 1st of July 2014. Note 2 of Rule 11C.
in case the government employee opts to get his pay fixed
In the higher grade
higher grade
from the date of his promotion, he shall get his first increment in the higher grade in the next one for July.
like 2014.
Yes. If he was promoted between the period from 2nd July to 1st January. However, if he was promoted between period commencing from 2nd January and ending on 30th June of a particular year, he shall get his increment on 1st July of the next year. So he has to opt.
As he from 2/1 to 36,
Yes,
then he will get it from July 2014.
July 2014. So he'll have to opt. If he doesn't opt, that means you are not, you come in the normal thing.
And what is note 1?
Note 1 says, in case the government employee opts to get his pay fixed from his date of next increment.
So his next increment is of 1st of July 2011.
No, we are concerned with 13 million. 2013.
No. Your increment is when? Mr. Sharma,
Yes.
when is your next increment?
I increment in case I do not opt.
What was the next date of
Next
increment?
increment was 1st of July 2020, 2030.
So you were 2013.
It
Now-
comes every year. It's an annual increment.
So you were therefore entitled to increment on 1st of July 2013. But as you were now, how does note 1 work? If in case of an employee opts to get his pay for his date on the date of his next increment, then on the date of promotion, pay in the pay band shall continue to be unchanged. Will remain. But the grade pay of the higher post will be granted. Yes. So you will get the grade pay of pay will remain unchanged. Pay band will remain the same. Now, just for example, you were in pay band 1, you will remain as pay band 1, but you won't get pay band 2. But there will be a change in the grade.
Yes, the rule one says, my pay will get changed. Will, the rule one says, rule one says, on the date of promotion, pay in the pay band shall continue unchanged. But the
So
grade,
if you are in pay band one, you remain as pay band one.
a pay band one,
You won't go to pay band two,
yes,
but your grade pay will change.
a grade page,
Means the next, you will get the grade pay of the higher grade. That is the UD. Then further, prefixation shall be done on the date of his next increment, that is 1st of July.
after
On that day, such government employees shall be granted two increments. An annual increment and the second on increment on ground of promotion.
in my case, my lord,
So what happened is you were to get it on 1st of July 2013.
Yes.
Your pay band remains the same. Then rate pay is increased.
I get two increments. One is annual and
Then
other
on first, on 1st of July 2013, you'll get an annual increment
the person as well as.
and plus promotional increment. Isn't it?
Yes.
Promotional increment. While completing these two increments, basic pay prior to the date of promotion and the grade pay corresponding to such pay in the pay band shall be taken into account. So grade pay will increase on promotion, but the calculation will be done on the basis of the whole pay band and whole grade. After allowing such a grade pay of the higher post shall be allowed. So after this will be. So your therefore case is that as you were promoted on 25/4/2013 and joined on 22/5/2015, your cases of 1/7/2013 you were entitled to one grade pay. You were entitled to one increment, annual increment plus promotional increment. And on the basis of the pay band as well as the grade pay of the post of the LDA. But after promotion, this increment is being given, then it will be done with the grade pay of the higher. That's it.
Yes, and my case is this, my lord, in both the case, in note one, cases covered by note one as well as cases covered by note, in both the cases, consent of the employee is asked. So
And if
my
there's no
consent was
consent,
not there.
if there's no consent, what happens?
It remains open, FIR.
It cannot remain open for all time.
That is how it is, my lord, Lordship may kindly see the rule 23, is with regards to FIR, rule 23.
Holder of the post, pay of which
Left
pay
page,
will be
page
paid
36 of my edition. Edition letter.
transferred to the post of the previous. That he may at discretion retain his full pay until the date which. Again, option.
Option, but the thing is that the option once exercised is final. In my case, this option opportunity was never given to me.
Understood. If you don't exercise the option, then what happens?
It can be revised. I'll be given two increments with effect from 1st of July 2023. Because this is then.
So they went to
definitely-
the second option.
Yes,
They
second,
went to the second
second
option
option.
without consulting you.
Yes,
That is your case.
yes, yes. And administrative lapse on the part of the employer.
Huh?
Then administrative lapse on the part of employer.
Show me somewhere
I
some
think-
judgment for that.
I don't have judgment.
You
right
have put me into a new area. Show me again.
I don't have.
Hey.
Maybe authority would be,
You
but
don't know, exercise the option. What is that? Mr. Bush, that day in that matter pertaining to Mr. Sharma, I have not granted the interest for the period from the date on which he submitted the representation from 14/7/24. Not granted. Prior to that, I have granted the interest. I have asked you to serve a copy to that district and session judge regularly. Coming to I've given you that direction, that the fact that you serve a copy. Yeah. And there should be stoppage of all further deductions. They have been, the accountant general has been directed to pay to you and are giving him the liberty within 30 days to file an application. You take that certified copy. Give it to them. Now give me something.
My lord, at page
Now,
72,
what
there
happens
is,
if you don't exercise the option?
what happens?
This is the case. They are on that.
Yes, only one, that yes, this opportunity was not.
No. What happens if you don't exercise the option? There will be judgments. It cannot be that Mr. Sharma has for the first time found out this particular thing. Didn't it, Mr. Das?
Yes. Option has to be there.
Huh?
If there is no option, then normal pay fixation.
Which one? There will be, you see, it has to be either one or two.
You know, this case squarely falls in note 2.
How?
It says, however, if he was promoted between period commencing from 2nd January and ending 30th June of a particular year, which is the case herein, he shall get his increment on the 1st July of the next year. This is when, in case the government employee opts to get his pay fixed in the higher grade from the date of promotion. That means if from the date of promotion, he wants the pay of
Again,
the,
option.
yes. So if he wants that my pay is to be fixed on the date of promotion, he'll have to give option.
Now, what is the, that's, if one person goes for the second option,
Yes.
does
Perhaps
he lose
assuming
anything?
there is no
Does
option.
he lose anything?
Because if I
I
consider
give annual increment, I lose.
No, it cannot be. Something will be there.
increment is
Because what happened in the first option, your pay and rate pay is taken, is to be considered of the old post. And as such, you will be given an increment, annual increment on the earlier post.
that is
On the
date
basis of the
fixed.
pay and payment and rate pay of the earlier post, plus a promotional increment. These are the two things you get. Once that is fixed, then your rate pay is increased to the next higher post. This is note 1. Now, note 2 says that if you opt, then what they will do from the next year, once you opt, you'll be given the higher pay grade, even higher PB. Just for example, you come in the PB2 with a high grade. And then in the next year, it will be 2014, July, will be entitled to him. Now, what is the loss you are having? Have you calculated that?
In my case, I have been given the promotional increment.
I am not understanding. Have been given promotional increment, whether it is given promotional increment or they have given you the other aspect.
Only promotional.
So that
Annual
means,
increment does not given.
no, that means you want to say that with the promotional increment being given, the authorities concerned did not go for option 2. So they go in for option 1. And therefore you are entitled to the annual increment.
Annual increment.
Now the question is whether you are given the promotional increment on the earlier grade pay, earlier payment, or in the subsequent.
My lord, I was promoted
3%, my lord, 3% of the
pay, because it has to be on the payment of one The great pay of the LD.
His, what he'll get upon promotion, previous, pay, basic, into 3%, whatever is come, that will be his, pay in the promotion pool. That increment has been granted to him as per. So what happened? This was in, on 2/5/2013. Now, his date of needs increment is July 2014. So if he opts that no, I want my pay to be fixed on the date of my promotion, then this note to come. And the yearly increment he gets in July 2014. If he opts, no, I'll carry on with my existing pay and I'll get my pay fixed on the date of next increment. That is July 2014. Then the note 1 comes into play. Because the very first two lines, it says, in case the government employee opts to get his pay fixed from his date of next increment.
No, understood, but question is,
Yes,
let us now go into those.
my lord.
Question is there, what is the loss? Because you see,
There is no loss.
on the option, when a person is given the option
Yes.
to exercise, he cannot be granted an option to his prejudice. No. An option can only be granted if when one may not like this or that, but cannot be to his prejudice. The moment he is to his prejudice, then you have to put him to notice. So therefore, what is the difference in between the two?
Actually, what happens, my lord?
And what would happen if note 2 is being taken and not note 1?
This is basically, this is a facility given to the employees. So this rule 11. Suppose an employee is earning ₹100. So in the month of May, so he will get his normal increment in July. He'll get his normal increment perhaps July 2013. So if he is given the pay fixation of the promoted post in the month of May or June, then he'll lose this one increment which he has worked for the entire year. So this is an option given that you continue with your existing thing, you earn your July increment, and you opt to fix your pay on the July 2014. So by virtue of earning this increment, his basic pay got raised.
So what is the loss?
There is
What
no
is the
loss.
loss
I
of
can
the
there is no loss. This is for the benefit of the employer.
So therefore, you are to therefore show it to me that there is no loss in either of the case. But if there is a loss to him, then you are to put him to notice. Thereby give him, say that you have a right, although the law says how it will be done, he has to opt. But the law, whatever may be, when anything is to his prejudice, then he has to know.
Yes, yes.
So therefore, what is the difference?
If I
I understand the formula. The formula is which I can understand after you take. He being an LDA, he was promoted on 25/2/2013
yes,
and he joined on 2/5/2013.
yes,
His right to annual increment, which is there in 11A, is on 1st of July 2013.
yes,
Now, he has the first option. Okay, that he would take the annual increment on the earlier payment of LDA.
yes,
Although he is promoted, earlier payment of LDA, and further also on the earlier payment as well as the break pay of the LDA, 3%. And then thereupon, his pay will be fixed and plus the grade pay would be given at the new post.
Yes.
So the grade pay will be, so what he gets then, an annual increment and a promotional increment. These are the two he gets there. Second option is he getting promoted on 25/4/2023 and joining on 25/2023 could not be entitled to the annual increment on that day of the year July 2013, but would be entitled to the annual increment of July 2014. But from the date on which he is promoted, he will be promoted on the higher pay grade and
Higher grade pay, higher pay and grade pay,
grade.
and he'll get this promotion increment on that day itself.
Where's the promotion increment in note 2?
No, it is already there in note 1.
So therefore, why does note 2 does not say about promotion
Yes,
increment?
no, only deals with the situation wherein the employee opts to get his pay fixed in the higher grade from the date of promotion. That means he opted that from 2/5/2013, my pay is to be fixed in the higher grade or higher post.
Now tell me one thing. You were joined on 2/5/2013. What is the salary you got on 2/6/2013? Because you have been already promoted. Did you get the salary on the higher grade? And if you have got the salary on the higher grade, then you could not have got it. See, you must have got the salary in the high grade because you're on promotion. From the date of his promotion, the promotion is with effect from 25/4. No, not what happened. In a specific situation. Note 2 comes into play when you opt for getting the higher pay grade. Okay. Now, when you got the higher pay grade, because your promotion date is on 25/4/2003, and you joined on 2/5/2013. So you must have got the salary in the next month.
Yes,
Now, did you get the salary next month on the higher grade, higher pay grade and grade?
it was given at higher pay grade, but my annual increment was not there. That did not include my annual increment.
They cannot be.
Yes,
So therefore, did you say, then also because you still had one more month
yes, one more month.
to opt. Did you opt then? Because you got a higher pay grade. Now it becomes irreversible. That is why it says
I
that
don't-
once you do it, it becomes irreversible. Coming back, and then, I think this is the answer. Liam took Mr. Dutt.
Yes.
Because normally I would have gone for that, but he must have got his salary on 2/6.
Yes, yes.
And then was it in the high grade? And if it, no, was it on the high grade and with great pay? And if that be so, then he had the option then also to say, but why didn't he, when did he did it at a later point of time? They could see from the order.
Petition
Where is that improved order?
Annexure 5, page 17.
Yeah. He say, you filed an application on UPS, you filed an application taking that only month. So you filed the application on 27/4/2016. Why after such a long time?
I filed one representation, I submitted one representation.
Well,
It was on 2nd of June 2016.
16.
Yes.
So why after 3 years?
Lord, everything is reflected in the order. Annexer 6, page 18, paragraph 1 and 2.
More particularly paragraph number 3. More particularly paragraph number 3.
Paragraph number.
Notice.
My lord, little bit of delay was there. But the only thing is that our coded
Mr. Asana. The council is hearing on behalf of Pitas, the learned standing council of the Guwahati High Court, who appears on behalf of the respondent members. 2, 3, 4, 3 and 4.
3 and 4.
The PR will go, Taragot Divigo, here's corresponding number 1. The petitioner has approached this court challenged the order dated 11/9/2017, whereby respondent number 3 from the court by an order date by the said order have refused to grant him the annual increment to which the petitioner claims to be entitled to. Question therefore arises in the instant proceedings is as to whether the respondent number 4 was justified in rejecting the application filed by the petitioner on 27/4/2016. Whereby the petitioner claimed annual increment with effect from 1/7/2013. The facts involved in the instant case is on a very narrow compass. The petitioner who was working as an LDA in the establishment of the district and session judge Kukrajan was promoted to the post of UDA. Here to lower division assistant. On 25/4/2013. And the petitioner thereupon joined his services, joined the post of the UDA with effect from 2/5/2013. There is no denial to the fact that upon the petitioner joining the establishment on 2/5/2013 in the promotional post, he was allowed to draw the pay of the UDA with the relevant pay band and grade pay. However, it is the case of the petitioner that the petitioner was not permitted to exercise the option at the time when he joined the post of the UDA. to claim the benefits in terms with note 1 of Rule 11 of the Assam Services Revision of Pay Rules 2010. For short, the rules of 2010.
Beg your pardon. Sir. The delay part was explained in the this order passing through order. Probably delay was addressed to and it was condoned also. And we take note of.
They may be condoned. 2010. In view of the above facts, the question therefore arises as to whether the petitioner herein have been deprived of his rights by not allowing him to exercise the option in terms with note 1 of Rule 11 of the rules of 2010. And establishment of the respondent number 3 and 4. Respondent number and establishment of the district and session judge Uprajan having opted for note 2 of Rule 11.
Yeah. He was promoted to CBI court for the district.
CBI, na?
Yes. Special Judge CBI Assam, additional court number 2, Chanmarika.
Establishment of the
Special
special judge CBI Assam.
additional court number 2.
This court finds it relevant to take note of that the petitioner had submitted a representation raising the same issue on 27th of April 2016. Stating inter alia that the petitioner was not allowed to draw his increment when he was released from the said establishment, nor the petitioner was allowed to draw the same after his joining in the present service. This court have also taken note of that after the filing of the writ petition, affidavits have been filed by the respondent numbers 2, 3, and 4. Respondent number 2, as well as by the respondent number 3 and 4, explaining as to why the petitioner have not been granted the annual increment in the year on 1st of July 2013. At paragraph number 12 of the affidavit filed by the respondent number 3 and 4, it has been mentioned that Rule 11C, Note 2 of the Rules of 2010 provided that one who gets promoted between January 2000, between 2nd of January and 30th of June of a particular year shall get increment on the 1st July of the next year. Bracket 1st July 2014 in the case of the petitioner, bracket close. It was mentioned that the petitioner therefore was ineligible to get the annual increment from July 2013. Referring to Rule 11C, Note 1, it was mentioned in the affidavit that in case a government employee opts to get his pay fixed from the date of the next increment, then on the date of the promotion, comma, pay in the pay band shall continue to be remain unchanged, but grade pay of the higher post shall be granted. Further, refixation will be done on the day he gets his increment, that is on 1st of day of July next year. And if he is promoted between 2nd of January and June 30th, it was also mentioned that on the same date, that is on 1st of July, he would be entitled to two increments, that is one annual increment and one promotional increment. The petitioner, however, did not opt to get his pay fixed as per the provisions of Rule 11. It was also mentioned that Note 1 of Rule 11C of the Rules of 2010 further provides that the option once exercised is final. In the backdrop of the above pleadings, this court have duly heard the learned counsels appearing on behalf of the parties and have duly perused Rule 11 of the Rules of 2010 as well as the impugned order dated 11/9/2017. For the purpose of deciding the dispute, it is relevant to take note of Rule 11. Take note of Rule 11 of the Rules of 2010. Where do I find it in your ROP? Page? Of the Rules of 2010, which is reproduced here in below. Page. From a perusal of the above rule, it is seen the above rule is in relation to fixation of pay on promotion on or after the first day of January 2006. In terms with subclause A of Rule 11, there shall be one increment equal to 3% percentum of the sum of the existing pre-promotion pay in the pay band and the grade pay corresponding to the pre-promotion post plus ad hoc fitment benefit, if any, which shall be computed and rounded up to the next multiple of 10. In terms of clause B, in case of promotion to the post, in case of post to promotion post, revised pay in the pay band shall be fixed by adding the amount arrived at clause A above, at clause A of rule 11 to the existing pre-promotion pay of the employee in the pay band. It is also mandated that the officer shall also be given grade pay at the enhanced rate as applicable to the promotion post. Clause C of Rule 11 is of vital importance, which is in relation to a promotion from one post to another, involving movement from one pay band to the next higher pay band. We stipulated that if the revised pay so arrived at consequent to promotion becomes lower than the minimum of the higher pay band to which the officer had been promoted, then his pay shall be fixed at the minimum of the higher pay band. And after such fixation, the officer would automatically move to the higher pay band to which he is promoted, and he will also draw grade pay as applicable to the post to which he had been promoted. Note 1 and Note 2 provides option to the officer concerned. The option in which is to be exercised in terms with Note 1 on the date of the promotion. The option is which is to be exercised by the officer in terms with Note 1 and Note 2. In terms of Note 1 is on the date of his promotion. To the effect that he would claim refixation of his salary on the date of the next increment, that is 1st of July 2000 or July. And if such option is exercised from an employee, shall be granted two increments, one annual increment and the second on account of the promotion. However, this increment, these two increments will be computed on the basis of the basic pay prior to the date of promotion and the grade pay corresponding to such pay in the pay band shall be taken into account. It is only after allowing such increment grade pay of the higher post of the scale shall be allowed. In terms with note 2, the case of the government in terms with note 2, the government employee can opt to get his pay fixed in the higher grade from the date of his promotion, and he shall get his first increment in the higher grade on the next 1st July. If he was promoted between the period from 2nd of July to 1st January. However, if he was promoted between the period commencing from 2nd of January and ending on 30th of June, he shall get his increment on the 1st of July of the next year. In the instant case, it will be seen that the petitioner was promoted to the post of the UDA in the establishment of the respondent number 3 on 25/4/2013, and he joined the post on 2/5/2013. Thereupon, the petitioner was granted the next higher, was granted, was paid the, and thereupon the petitioner's pay was fixed in the higher grade of the UDA from the date of his promotion. The petitioner continued to avail the benefit of the same higher grade pay, higher pay in the relevant pay grade, pay band, and grade pay. Till he submitted his application representation on 27/4/2016. We could have further taken note of that when the petitioner was promoted on 25/4/2013, or when the petitioner was joined services on 2/5/2013 in the higher grade, that is in the post of UDA, the petitioner never exercised the option which he was required to exercise on the date of his promotion. Considering that the petitioner did not exercise the option on the date of the promotion, this court further takes note of that even when the petitioner received his first salary in the high grade, then also the petitioner did not take any steps. Considering the above, it is the opinion of this court that the petitioner now, after 3 years, cannot, by filing a representation, request for change in the same, as it would go against the very mandate of Rule 11C, as well as Note 1 of the said rule. Considering the above, this court finds no merit in the instant petition for which the petition stands dismissed.
Much. Then 3 to 7.
This is the government advocate. What do you have? What has happened to the rules?
Total letter to the concerned authority on the this time. I have not received the instruction for the
Where is the DNR?
black. But fine.
We'll have it at 2. But before we get the instruction. So from the rulemaking committee, it has been done on 11/10. So that has been done, we are in the month of May. So that is the only now finance objections which were there, all have been taken care of. Everything has been accepted. So now what remains for them not to notify? 2 o'clock.
Image. We have filed an IA melody for impeachment of the party. IA number 1 to 82.
We filed an IA. Yes. To make the state of Guwahati High Court a party.
Yes.
To make them a party.
Number 4, this is page 4 I've mentioned. Earlier there were 3 respondents.
Hey, yeah. Asking people why this sound.
Earlier there were 3 respondents, my lord. The state, the commissioner, finance department, and the CM. Then on the last occasion, very much whether the record was made a party. Yes.
The High Court is not made a party, we have filed this application for increment of. The affidavit has been filed by the CPL.
Why you have not been paid the salary?
We are saying, my lord, there is no financial, there's an audit of this. But we were working, my lord, and to that effect, my lord, the CGM has also given a certificate. We have annexed in our requisition, my lord. That is a page 51. One find there were prayers, my lord. One was for regular, one was for the period. Regulation part, since I have been in the group, that is one. Only the area part is there. For the area part, my lord, in the affidavit, in the requisition, my lord, at page 51, the CGM has itself stated that, my lord, I was working as on case, my lord. I was working till November 2015. In my affidavit in reply, my lord, I have stated the period from which I was working, my lord.
You were working as,
I was working as a manual worker, my lord.
where's the finance? For finance. Finance is a party.
Finance is a party.
What is their stand?
They have not filed an affidavit. Only the CPM has filed an affidavit.
What is the stand of the CCA?
They are saying, my lord, there's an audit objection. Para 12, they've stated in the affidavit, there is an audit objection.
Now, in view of the, Mr. Nath, in view of, Mr. Das, in view of that particular government of Assam memorandum, there can be no regular employee work for sweeper. So it needs to be done outside, outsourced. These people were outsourced. Outsourced only, they have been doing, huh?
They were not outsourced also. They were a contingent manual.
Yes, but they were given, they cannot be a post-being paid. It needs to be outsourced. So they have outsourced it. Once you are not in the cadre, is outsourced. You are not giving him the regular salary which a sweeper would get. What are you giving him?
I
You
was
are
paid
giving him some stipend or something.
Yes.
They will 10,000 or 7,000,
I was paid 9,000 per month.
9,000.
Yes.
So this is being outsourced.
Till date, there was sanction from the finance. Till the date, there was sanction from the finance department. They will continue to be paid. Thereafter, as per the audit objection, there the payment was stopped. That is what. The
So
affidavit is.
does the finance department think that for the CGM, there is no requirement of sweepers? Who's going to clean? The CGM? Who's going to clean it? Office peon? Where's the finance department? Fellow non-APS, direct the finance secretary to appear. The video.
About the Commissioner Secretary Finance.
They have not filed the affidavit also. We direct the finance department, commissioner and secretary to appear. Their names have been shown in the post list.
Yes, madam. SC Finance.
Huh?
SC Finance name is good. No, name is SC Finance is good.
That is enough. So we make, direct the finance department, finance secretary or whoever to appear. There's an application filed seeking improvement, filed by the petitioner seeking improvement of the Guwahati High Court. Presented by the Registrar General, Guwahati High Court at Guwahati 78100 as a respondent number 4 to the instance. taking into account that the Guwahati High Court exercises jurisdiction under Article 235 of the Constitution. It of the opinion that the appointment of that the Guwahati High Court is a necessary party to the instance. Accordingly, this court allows the instant application, thereby increasing the Guwahati High Court presented by the Registrar General Guwahati as the respondent and the accompanying requisition. Petitioner or petitioners
Petitioner.
will file an appropriate application, file a fresh memo of dispute score and raise itself on the basis of the within 3 days. Within 3 days, raise itself on the basis of memo of parties. Necessary correction of the cost title as well as update in petition on the state as the learned standing council of the Guwahati High Court appears that he accepts notice on behalf of the Guwahati High Court duly implemented respondent. Before they submits that the stand which has been taken him. The respond number 3 shall also be the stand of the DAS. Yeah. PPM stand would be the same with the High Court.
Yes, ma'am. Same thing.
So we now push it up, directing the Commissioner and Secretary to appear in person. Here. Judicial magistrate.
I am appearing. I thought it proposal is submitted to us for present of the area.
We have rejected it. We have given an audit objection. Now tell me, Mr. Gugoi, tell me one thing. You have an office memorandum or memorandum to the effect of the finance department that in respect to sweepers and all, there has to be an outsourcing. Now these people have been outsourced out there as contingent workers or whatever may be. They are not entitled to regularization. That is different. But they are entitled to that salary of this 9,000 which is being given to everybody. Now we want that the CGM should come down and clean the thing. Well, then how will these things work? No, this is what has happened. Kindly see this affidavit. Audit objection is being given. Judicial, I am directed to convey the sanction of the governor for engagement of casual employees. This is being done. Renewal of sanction for engagement of so and the allotment of so and so is so and so. Already been received by the office of the year. Proposal has been submitted. And let's see the affidavit which has been filed by the CGM. Where is that?
Page 70.
The answering of a respondent begs to state that the senior accounts officer, GS Office of the Accountant General Audit, in its audit report raised objection pertaining to making payment to the petitioner and few other similar. According to them, the Chief Judicial will stop the payment of remuneration of the petitioner along with the amount as no approval from the finance department was obtained. The Chief Judicial wrote letter to the Chief Judicial seeking financial approval for engagement of the petitioner and others, but standing in the same footing and engaged. Accordingly, later they were written to the Judicial Department. The Judicial Department sanctioned engagement of 2 numbers and 3 numbers of casual for the financial year 2019-20. Due to the financial agreement with the four others to work as casual employees accordingly by nature with the division sanction re-engagement of 5A1, including that for the financial year 2000. Since there was sanction and approval from the real petitioner along with the others similarly were paid their respective issues. Now, where is it? They are saying that from the month of Iman, the payment of the commissioner was stopped due to audit objection and there is no record of rendering any service by the commissioner. Failed to produce any document. The commissioner is not in. Now you are asking for which period?
When the writ petition was filed, my lord, I had paid for
September.
September 18 to December 2019.
Then
Thereafter, my lord, my affidavit in reply, I have also shown that there were some other periods also. So I have to amend my repetition if I have to report that.
oh no, I am not on that. But tell me,
My
you are
period, my lord,
asking,
is
you are
from
asking the payment from September to December.
September 2018 to December 2019.
Now this CGM says that there is no record that you worked. In paragraph number 12.
My lord, may kindly peruse then, my lord, page 51 of the repetition, my lord.
Page
51. The CGM himself, the CGM itself says that I've been working as contingency manual worker in the office from 2013 to till date with entire satisfaction. Page annexure 20, my lord. This is dated 19 August 2021. And during the COVID period also, I was asked to work, my lord. I have also in my reply, I have enclosed annex.
No, we are not on that. We are only on the question of September 2018 to December 2019, because that is your prayer.
Yes, ma'am.
We are not asking for anything else. We are concerned with only prayer A.
Yes.
Okay.
So
Now
that-
here the CGM says
I was
this.
working.
CGM says this,
Yes, sir.
that you have, you are not working.
So he himself says that I'm,
Paragraph number 12.
yes, that is it, but that document in my repetition, it says that I'm working. Page 51.
How do you explain?
But apart from page 51, I am more concerned about the documents that he has annexed in the additional evidence. Page 51 is a certificate. The certificate is altogether, but in the additional evidence, he has annexed documents issued by the CGM, which provides that this person has worked. So
Huh?
that's why we provide additional evidence.
Is there any additional affidavit, please?
Sorry, affidavit reply. I'm sorry. Affidavit reply.
That starts from page 83 onward.
It contains order. So in that case, I'll have to take this instructions from the CGM. What context we not,
Page 83 onward. Sir.
page 83, if you also kindly
So
consider.
this is of 2021. We are not
Exactly.
concerned with that. Then 21.
21 also says that,
These are all 21.
yes,
We are not concerned with that.
I had worked in August 22, but
No, I'm not on that. Your only prayer out here is why you have not paid for this
area SLA for this
18 and 19.
19.
Now 18 and 19, what is your reply to paragraph number 12? Why you are concerned with the others? Other documents. His prayer is simple. His prayer is only A. We are not concerned with B, C. B and C is impossible to give because this is not the government is very clear to the effect that there cannot be any regularization in minimal worker.
That I have, so I cannot clear.
So that is
Only for the area SLA.
only A is there. He is only asking from September 2018 to December 2019. Page 23 of the repetition. Okay. Now, page 51 of the repetition shows
certificate.
the CGM gives a maybe with looking or without looking, I don't know, with that certificate. Then this certificate is there in the repetition. Then also the CGM says that paragraph number 12.
Yes.
That there's nothing on record that he was there from September 2018 to December 2019. Okay. Now, what is the reply to paragraph number 12 will be again coming back to
I have denied it, my lord, but I have also reiterated
what receiving fee.
para 4 of my affidavit in reply
What do you say in paragraph number 16?
of the writ.
Paragraph number 16 of your reply.
Respond, the petitioner, they have admitted that I was not paid the salary because of the audit objection.
You are not engaged. If you are not engaged, then why is this? How are you, what is the paragraph number 16 of your affidavit in reply? Read it. From the pleadings so made by it is thus evident that the respondent number 3 admitted to the fact that the area salary from September to Jan has both been paid to the petitioner. What is this statement?
It not, it should be not.
Huh?
Because the area salary has not been paid.
Then the entire sentence goes.
Yes,
Now
sir.
tell me, if he has denied, except that document at page 51, there is no other document.
Area salary has not been paid. Otherwise,
No, after document is not. Now, where is your engagement from September 2018 to December 2019?
that it is not part of the report.
No, then
But the point
the,
is, my lord, that this, in page 20, page 51 of the.
no, 51, I don't know what is it. But where is your engagement?
Engagement, I was engaged from time to time, my lord.
No, all engagements you have enclosed.
Yes.
But why you have not enclosed the December 2018, September 2018 to December 2019?
That, that is not there. But if the records are called for, my lord.
Why should I call for records? You have called for all, you have written everything out here, you have enclosed all documents of your appointment. But there is no document of your appointment from September 2018 to December 2019.
And there's another period, my lord, for which, my lord, I have to amend my petition because the subsequent period, in my affidavit in reply, I have also stated that this period I have not been paid.
Let me dismiss this petition, then you
From
file
May
another one.
21 till August 22.
And another one. Then that is outside the scope.
Because after the filing of the petition, this period I was working and I was.
That is a different case, Mr. Khan. But here there's nothing. You could not produce that you were appointed. Again,
Or let the petitioner be provided an opportunity, give a detailed representation to the
Why?
concerned. If he
oh,
can
Mr.
satisfy-
Khan. Mr. Khan, you know that I take a bench one, but that doesn't mean that I'm going to give representation business. I'm very stingy in this type of orders. You have to have a legitimate right, legitimate expectation. I have to come and find it and have an opinion that you have a legitimate expectation, then only representation. It is the toughest order which you can get it in. What is my court number? 14. You get it everywhere, but not this. Representation businesses.
Because my lord,
Yeah,
the document which I have,
there is not trouble and only give Mr. B. Gogoi benefit of standing up there. You file for the other period, you keep on paying. But not for this. No business out there. Heard Mr. Scound the learned counsel. Let me come back at 2 and dismiss.
List. Item number 1,
pertaining to Itanagar bench and connected item 12 of the daily list.
Petition is start. Itanagar. And we come to phase 2. The clause 7 is the petition list of AOG.
Where is the petitioner?
My lord, here my lord, 3 AOG are there, and petitioner is a phase 7, petition list of AJ. Phase 7, clause 11. But 3 senior to the petition in the AJ cadre.
No, but the petitioner herein will come within the ambit as it is one is the.
Yes, but the 1 for 1 plus 5 will be considered. It appears that
So here the open communication by which the petitioner has been deprived from consideration has to be in the. But rule 7.
7.
Now, to become esteem register, which are the feeder categories?
AOJ.
Not only erosion, the minimum.
Yes, it will class 2C. Number 1 is AOJ. Number
2C and 2D.
yes. 2B, 2C.
We private secretary grade 1. Grade 1. C.
Only thing is, my lord, there is one difficulty.
There is no 2D. As of now, we don't have a 2D. Is there any post of 2D in Chanagar? But the problem happens here. There's a big problem here.
My lord, there is one more thing. This
Hmm.
civil one has not been adopted by India.
So
That is
therefore,
the problem.
therefore, in between them, you have much higher persons who are in the grade. Just for example, the private secretary is there.
Yes, ma'am.
Librarian come research officer is there. System analyst is there. Administrative AI is number 8. So 8 will become, means AOJ and court officer. Here AOJ and court officer are on different pay grades. It is. One is in Paven 8 and one is Paven 7. Either is done when? This is 7 PC. This is not as per 7 CPC. Schedule 1 is not as per 7 CPC. Na? So they don't have the post of stamp reporter. And what about private secretaries grade 1? Do they have private secretary grade 1?
Yes, my lord, private secretaries, they come under 2B. As per the schedule.
But therefore I'm saying, where is private secretary grade 1? No private secretary grade 1. Your personal assistant.
Yes, sir. It's better when they file affidavit.
Now you kindly see this fellow.
In which paper?
To number 6. To the assistant accountant come cashier. Okay, fine. So he is presently holding the post of assistant. Now appointed and joined as LBC on so and so, promoted to AJ on 27/6/2016. Here if you put 4, then bring the petition out here as 5. But for doing so, again, you have to have 18 marks out of 30. Isn't it? In the ACR, to come within the zone of consideration, he has to have 18 marks out of 30. Okay, Watson? See I could get hold of some documents. This is the first one why we have that 1:5. Fine. Let's see out there in 2011, something has happened. Then 2013, then 2015. Now here it says, which was put up, minimum eligibility criteria for being considered for promotion may be fixed at 18 marks out of 30 in the ACR. So he has to have 18 marks to be considered. Now the problem is, how do you go to the 18 marks? Now, these 1, 2, and 3, who are the AOJ, they still may not have 18 marks. They may have or may not have. Now, if they don't have it, then they are to be taken out. So first, what is required to be done is, there has to be looked into on the basis of that. Then it has to go as per seniority. What happened? Seniority business. No, you said that you are going to look into that. Ah. That when it is show me that if it is not mentioned also, then if it is not mentioned in the rules also, then the seniority, because that will help this court how to do it.
This is how it reads, my lord. The rulemaking authority is competent to frame rules laying
Now,
down.
what is the judgment?
Citation is 1988 to SCC 233. It 1988 to SCC 233. R. Prabha Devi and others versus Government of India proceed. There, the last paragraph I found. What is it? There was a fight between the promotees and the directly, that is seniority and eligibility and all. Says,
So there the notification did not say it.
yes, how amongst them it will be done, and they were saying that whether eligible or not, we are senior, we should be always taken care of. At the end, it says, the rulemaking authority is competent to frame rules laying down eligibility condition for promotion to a higher post. When such an eligibility condition has been laid down by service rule, it cannot be said that but towards the end, my copy does not have the para numbers.
You properly given.
Third last para. In the 1984 amendment, it starts with
Start with
the 1984 amendment of the rules towards the
yes.
1984 amendment of the rules providing an eligibility condition for rendering 8 years approved service as section officer for coming within the zone of consideration for promotion to grade 2 post of CCS is not at all arbitrary and unreasonable, as it prescribes a minimum period of 8 years of service as section officer for direct goods and promoted as a condition of eligibility for consideration for promotion to the higher post. This rule is therefore not violative of Article 14. The rulemaking authority is competent to frame rules laying down eligibility condition for promotion to a higher post. When such an eligibility condition has been laid down by service rule, it cannot be said that the direct report who is senior to the promotees is not required to comply with the eligibility condition and is entitled to be considered for promotion to a higher post merely on the basis of his seniority. The amended rule in question has specified a period of 8 years approved service in the grade of section officer as a condition of eligibility for being considered for promotion to grade 1 post of CCS. This rule is equally applicable to both direct report section officers as well as promoted. The submission that a senior section officer has a right to be considered for promotion to grade 1 post when his juniors who have fulfilled the eligibility condition are being considered for promotion to a higher grade higher post grade 1 is wholly unsustainable. The prescribing of an eligibility condition for entitlement of consideration for promotion is within the competence of the rulemaking authority. This eligibility condition has to be fulfilled by the section officers, including senior direct recruits, in order to be eligible for being considered for promotion. When qualifications for appointment to a post in a particular cadre are prescribed, the same have to be satisfied before a person can be considered for appointment. Seniority in a particular cadre does not entitle a public servant for promotion to a higher post unless he fulfills the eligibility condition prescribed by the relevant rules. A person must be eligible for promotion having regard to the qualifications prescribed for the post before he can be considered for promotion. Seniority will be relevant only amongst persons eligible. Seniority cannot be substituted for eligibility, nor can it override it in the matter of promotion to the next higher post. The rule in question, which prescribes a uniform period of qualified service, cannot be said to be arbitrary, unjust, violative of Article 14 or 16 of the Constitution, which has been applicable. Once the eligibility is fulfilled, then seniority will become legal. Then and only then. So while taking those,
That is for seniority to merit.
may consider. First, first it has to be taken that a man has to be eligible. Then according to the seniority, he will come into the zone of consideration. Thereafter,
See this, and to come to paragraph 5, the judgment. Paragraph 5, it starts with, thus according to this proviso, Sub-Rule 2 of Rule 12, a direct recruit section officer who had rendered 6 years active service in that grade was eligible for consideration for promotion to grade 12. Whereas a promotee section officer who have to render 10 years active service in the grade section of grade before being eligible for consideration for promotion. In 1979, the substantive part of Sub-Rule 2 of Rule 12 was amended to provide 8 years active service in section officer grade as against 10 years active service for eligible for promotion for grade 1 CSS. The third proviso to Sub-Rule 2 of Rule A was further substituted by following proviso by notification. Provided further that if any person appointed to section officer grade is considered for promotion to grade 1 under this sub-rule, all persons senior to him in the section officer grade belonging to scheduled caste or scheduled rendered here is not person approved, that grade shall be considered. And before that,
scheduled caste and scheduled tribe, it has been brought to 4 years. For scheduled caste and by this proviso, scheduled caste and scheduled tribes with 4 years, and if they are senior.
no, but how do you say that has to be taken on the basis of seniority? The zone of consideration.
Once they are eligible persons, the persons who are eligible for promotion will be many in the gradation list. Amongst those eligible persons,
Who will be the eligible here?
those who fulfill the required qualifications for the next upper post, be
What is the required qualification?
it by way of having some
It is merit cum seniority, simple. Rule 18 says it is merit cum seniority. Now, this notification which has been issued states that we are going to first take into for bringing them within the zone of consideration. They are to be assessed in the ACR and they have to get minimum 18 months. This is it out of 30. So how for 5 years? It also means one can assume from that notification or presume from that notification that he has to be there for the 5 years. 5 years or whatever minimum 5 years. Otherwise we get it. Now, once he comes under 5 years, he does not, from whom are you going to consider? Are you saying that as it is one post, first 5 will be looked into as per seniority. And thereupon, if there is nothing, the next one will be looked into.
I was trying to propose this. There are 10 people there. The first 3 persons, they do not fulfill the 18 months. They are directly out of the zone of consideration. fourth person has 18 months. He is the first person in the zone of consideration. Till now, we have not seen whether he has secured 30 or 12, 30 or 20. We just know 18 crossed, you come into the zone of. In that manner, the first 5 senior persons who score 18 come into the zone of consideration.
That is your basis.
That is what it says. Madam.
No,
The seniority will become relevant amongst the eligible persons. Otherwise, the petition list is formed, keeping a man senior to someone else.
seniority will be relevant amongst the eligible persons very well. But from who would be the eligible persons? This is the question. I'm on further on the route. You are going above. I'm saying who will be the eligible? From who will be the, what will be the zone of consideration for those eligible?
There's a person who secures 18 months.
So are you going to say that any person from SJ or AOJ, whoever has 18 is to be brought and looked into it?
SGS will not. SGS will not come in. The court officer can come in because he is in classroom is working and the AOGs. Amongst them, whoever secures that 18 months. they
On
will
the
have their
basis
own
of,
senior.
on the basis of what senior?
AOJs,
SJ,
AOJs will maintain their seniority in the AOJ rank.
AOJ is to maintain the seniority in the AOJ ranks. This cannot have any equivalence with the court officer. Because the court officer maintains the rank in the SJ.
Yes.
Then how do you look
So
into that?
even if he scores 18 marks, when he maintains his seniority in the SJ cadre, unless people above him in the SJ cadre have been considered for the post, securing 18 marks or not securing 18 marks, unless they are considered for some reason or other, he will not jump over them. He cannot jump over. He will have to await his turn once all the AOJs go, because AOJs are, he maintains a seniority in SJ, not in AOJ. So therefore, once if there are 5 AOJs on top of him, who secure those 18 marks, they are considered first. They move out, second lot gets considered. He can apply. He will be considered with the 18 marks, but if he doesn't fall within the 5 cutoff, he will not come in. His seniority will be according to the SJ. Now, if none of the AOJs are eligible to be considered, matter will fall down to him. Because as a court officer now he comes.
Now let us take a hypothetical situation where he is the court officer. He is the court officer. But the person who is junior to him is promoted to AOJ. Then what happens?
The person,
In the HA
the person will be promoted from SJ to AOJ. Prior to that, the court officer, the person who was the court officer had to be considered. If he misses the promotion,
So therefore, the problem which arises is this person came into and became the court officer in 2016 or 17.
yes,
So then he is much senior to all the AOJs. All other AOJs are gone. So now these are all fresh beds, but who are otherwise senior in the SGA cadre from him.
yes, they were SJ, senior SJs.
Therefore, how do you balance that problem? That is what my problem is. See, you need to balance it somehow. Yes, I am also in your thing that these AOJs who are senior in the SGA rank should be first considered. They should come within the eligibility. Or one can very well say that while taking into account the eligibility, because this court is going to hold that it is a promotional post. It's court officer.
As court officer.
Once it is a court officer, it's a promotional post. Now, if you don't maintain the AR with the AJ, SJA, how do you equate it? That becomes the problem.
One whole matter I had found where the Honorable Delhi High Court had tried to bring about the equivalence of posts or consider these posts to be promotion and all that worship is 1989 supplementary SCC 154. S.B. Mathur and others. Versus Honorable Chief Justice of Delhi High Court. I could not go through the whole of the judgment, but
What
here
is
what
that,
I found
19?
was 1989 supplementary SCC 134. S.B. Mathur and others.
Supplementary.
Supplementary.
There's no 1, 2. Only supplementary 1, supplementary 2, no.
Supplementary 1, document is supplementary 1, page 34.
1.
Think it's not it. 89.
Okay, 2.
S.B. Mathur. Here there was some question of equivalence, right?
That as of 22 may have a relevance.
Not 130, it's 34.
As of 22. Coming to the next submission of Mr. Kapoor, have you got it? Was submitted by him that the interpretation placed by the Chief Justice and the learned judges of the Delhi High Court on Route 7 of the said appointment and conditions of service was incorrect. So they urged by him that even if the combined seniority list is valid, it could not be applied for the purpose of promotion. In dealing with this argument, we may briefly refer to Rule 5 of the said seniority rules of 1971, which clearly provides that the joint inter-se seniority of confirmed employees in categories of equal status posts shall be determined according to their dates of confirmation in any of these categories. Post of superintendent, postmasters, and private secretaries to the honorable judges are equated to as equal status posts under Schedule 1. The said seniority rules 1971. The same like 2C. Framed under Rule 2. Rule 7 of the establishment rules merely states that except for employment of appreciating temporary or ad hoc basis, the mode and qualification for employment to the post specified in Schedule 2 of the seniority list shall be stated therein, and the item number 3 of the same year, to which we have already referred earlier, shows that the appointment of the assistant register is to be made a selection on merits from the confirmed officers in category 5, 6, and 7 of class 2 mentioned in so and so. So here it's similar to Rule 18 read with Rule 7.3. The only ground on which the validity of Rule 7 is challenged is that if it is applied in the zone of consideration restricted on the basis of the combined seniority list, the prospects of promotion which the superintendents enjoy would be reduced. We find ourselves totally unable to appreciate this. In the first place, it is not as if either the Rule 7 of the external or area which provides for combined or joint seniority list negatives chance of any promotion to the post of assistant register being granted to the superintendent. In fact, several superintendents have been promoted to the post of assistant register after the state rules have been made. All that has been pointed out by Mr. Kapoor was under the combined seniority for some time. Relatively fewer superintendents would be the zone of consideration for a post of assistant register Let's go. We fail to know and swear. In the first place, it is well settled that no employee that bad. But makes a big difference. For the new urge that reference to the categories of 5, 6, and 7 without reference to the combined seniority list indicated that even if the zone of consideration was to be restricted on the basis of seniority, this could be done only according to separate seniority lists for each of these three categories, and that the combined was not to be used for the purpose of limiting the zone of consideration. Accordingly, the learned counsel for in our view, this argument is unsound and cannot be reference to categories 5, 6, and 7 in item number 3 of is merely made with reference to set out of the categories from which promotion or selection has to be made to the post of established. The language of the item number 2 will indicate that there was any idea paid anything like a quota for each of the said three categories. And in fact, reading fairly, the said relevant rules and the items of the schedule, it appears to us. Intention is to treat all these categories as forming a single class or category for the purpose of promotion to the post of year. So therefore, if we apply this law here, we can say, but it has to be on the basis of the combined seniority in the LJ. Although the rule says 7-4, say they will maintain the seniority as per this. AOJ will maintain the seniority. But that is an inter-se seniority amongst the AOJ.
For the purpose of promotion, the next.
For the purpose of promotion to the post of examination, it has to be taken on the basis of a combined seniority. This way, we can overcome this problem. And from there, the zone of consideration, the basis of seniority.
Eligible candidates. Taking this out of the ACR. Board of it. And only when they are not eligible, they will vote of it. Otherwise, the additional list will have.
So that means I have to read down rule 7-4. It means that the rule 7-4, so 7-4 says that AOJ shall maintain the seniority which as per AOJ, but it shall be for all purposes taken as seniority for the purpose of promotion. It shall be taken as only as a. And that is the combined
Officer will also be considered to be SJ. The court officer would also be there only in that combined list as an SJ.
because otherwise what will happen? But the High Court was creating a big problem to the defense. This court officer has a promotional post to establish here. And he, under no circumstances, can become an AOJ. Because he has already been promoted. Because court officer is not a feeder category to AOJ.
If court officer is taken to be the promotion, then he is already promoted to some other.
He's already been promoted, so it will amount to demotion of him. Become a to the SCA.
If we send out to the absent,
Demotion. There may be the order may be, which he may be reverted or whatever may be, that is immaterial, but that is the rule. So if he is promoted to SJ, then in that case here, so he cannot become an AOJ. So then the only way is to have a combined seniority list of the LCA. For the purpose of putting into consideration and then apply 1:5. And if he fits it, as per the,
When the private respondent.
but that process has not been done by the High Court.
What had been done was what private respondents that I represent, they say we are senior to him as AOJs. And SGS also we were senior to him. We were not in the zone of consideration because there were people senior to us who were being considered. He makes an I and he comes and he sits in the interview. If this is allowed to happen in that manner, anybody who takes a option of becoming a court officer from below us will always be
First of all, I don't understand how can court officer post can be optional. It cannot be optional because that is not there anywhere.
as the advertisement. At that point of time,
Forget about the advertisement. Advertisement cannot be the basis on which you cannot go against the rules. Now, how can the post of court officer be said to be optional when it is it's a career post? It has to be a regular post.
and it is a regular, it's a regular post. We are not.
So therefore, it cannot be optional that you only keep him only for some time and bring him back. That is not heard of in service jurisprudence.
Because they gave, they put it in the class 2C. Therefore, an encadering. That is where the entire fiasco
Problem
started.
happened when it was encadred.
Then the fiasco started. Had it been the excadable, it was always an optional part.
But they continued, the High Court continued in that
The
manner.
encadrement is created the confusion.
So therefore, it is a promotional post. Once it is a promotional post, you will be there, but this is how you have to read it. That only seems to be the only way out. And then if they will have to apply in that way. And looking.
And in that case, the writ petitioner would not have been in the zone of consideration.
No, first of all, they have made that mistake. See, whether they have taken, whether he would have been in the zone of consideration or not. How many persons are you going to take? First, you are going to take the first 5. Then you take the first 5. Out of first 5, 2 comes out. 2 does not meet the 18. Then you make it for another, for 2 the next. That seems to be the only way out. Otherwise, it becomes very difficult. Thereby keeping 7-3 as it is.
We got a promotion from when the SJ comes to the post of a court officer, it acts like a promotion, being encadred. But when an AOJ takes the post of a court officer, he goes for an equivalent post. For him, it will not remain a promotion.
That is why was
They
that
all
done?
take it together in the post of SJs, so that the
So therefore, 7-4 on the page of it appears to be wrong. This is not how you do it. 7-4. And you have put 7-4, and what happens to those translators? They actually come in 7-4.
Translators are 7. 7-4 refers to translator,
Translators.
not to the
And there you have superimposed 7-7.
that's 7-4 or something. There should be 1 or something is what was verbally
so that we cannot presume.
instructed, but
So the reasons given in that order is wrong. Reasons given in the order is wrong. And whether that's, then it has to be done de novo. By following that as
yes,
per the HA.
yes. Then those who fall into the zone, they are satisfied. Those who are waiting for to fall into the zone, it has to be okay. That is what administrative have to do.
Then from there, they will look again into merit cum seniority.
Yes, amongst the eligible, one with the maximum merit, one who is senior, which is
whichever way. What my landed friend is suggesting, but as I have, my friend is suggesting, saying that on the basis of the ACR marks, there will be pool. And from amongst that pool, there will be seniority order. That persons in the pools, there will be seniority order, and from top 5 will be taken against one person.
No. What he's saying is this. First, so seniority would be maintained by you in the HA, AOJ. We maintain the seniority in AOJ. That is there. But that is only for the purpose of inter-se seniority amongst themselves. That he says. But when it comes to the question of promotion to the post of assistant registrar, then a combined seniority list is to be required.
Combined with including all the posts under 2C and 2P.
All. This is what the Supreme Court also says in this.
Because my lord, if I may point out, rule 3, my lord, it's 7, sub-rule 3, my lord, it says the assistant registrar shall be appointed from among the judicial service grade 3 or by promotion from among the gazetted officers of the High Court service belonging to class 2B, 2C and 2D.
So therefore, you would have a chance of being a court officer. Being a court officer, and not you.
There will be
I'm not
separate
saying you.
seniority list.
A court officer also will come within the zone of consideration.
Consideration for here.
To come within the zone of consideration for being considered for the eligibility. Okay. Now you have a notification of 2021-22 or the all this thing, wherein it says that out of 30 marks in the ACR to be eligible, you are to therefore have 18 marks.
18 out of 30.
So when you have 18 marks, when the first 5, because it is 1:5,
1:2.
taking into account the combined seniority list, if the one person, first 5 doesn't get this, what you call, ACR of 18, then the second 5 will be taken. Second 5 does not get, third 5 will be taken, 18 out of 30, which is
Out of
60%.
6.
60%. So then these 5 would be taken into consideration for the purpose of filling up the post of assistant registrar. And from there, the merit cum seniority would be taken in the manner in which that notification says. This is what his submission is.
But so it's all right, but as your lordship has rightly pointed out, that there is the combined seniority list of these 3 groups, 2A, 2B, C and 2D, is not prepared. That combined seniority, seniority is not prepared.
So if it is not prepared, it will has to be therefore taken into account from the HA. That is what I'm saying. I have told him. Then that means that this court has to be read down 7-4, although they may be senior. In the AOJ, there might be, because the court officer does not have its independent, or 2C does not have its own seniority list. 2C does not have its own seniority list. Neither 2B has, neither 2A has. Independent seniority list is not there. They have a seniority list for AOJ, which is also not there properly. They don't have it. So in that gradation list, therefore, it has to be taken on a combined seniority list of HJ.
Combined with AOJ.
Seniority list of the HJ. You are entitled, provided you fall within the first 5 and have 60%.
But by assumption, if SA seniority list, it has a combined seniority list of SA is taken into consideration, then but then the SA is not a feeder cadre for estimation.
No. So therefore, that is not a feeder cadre post. But otherwise, these AOJs would still a march. You see, then all AOJ will get it, because they, whatever may be, They are having a, how do you gel both of them? You can't gel both of them.
The fundamental question remains, why, as your lordship has just pointed out, that the post of court officer is a promoted post, even it is said it's a, rule says it's a promoted post. If it is a promotion, and I came from a lower cadre to a higher cadre, following a due process of law selection and all, then the fundamental question remains that against the service that my seniority will be maintained in the lower cadre. The very.
That is the rule itself says.
That challenge.
Understood? The rule is under challenge, so what? I'm not here to decide the rule. The rule has been challenged for what? Why have you challenged the rule?
But these two things, when it is, the 7-4 is already there, one ground.
That is a wrong numbering of the rule.
But even then, my lord,
Wrong numbering of the rule cannot take away the legislative intent or purpose by which the rule has
there
been
one
the
ground
power.
of the challenge, but that one
You
ground of
may
the
put
challenge.
it 7-4B, 7-4C,
My lord,
whatever may be.
my lord,
It
that
is
is
in the name,
that is
it is
one
like a
ground,
rule.
but primarily it was challenge under this criteria, my lord, that when I have been appointed in a higher cadre post, my seniority cannot be directed to be maintained in a lower cadre. That is the primary challenge. One of the ground is that also, that it is not 7-4 is already there. For an argument,
But I am now reducing the AOG to senior SJ. Because otherwise, what is the difficulty which is being faced these days? Court officer cannot be the feeder category to AOG. Okay. That means court officer can only be the feeder category to the assistant register. Now, if the AOG only has their own seniority, how you take care of that problem later on? Then the court officer to become an AOJ and then become, which is their submission of Mr. Bush, will have a, their therefore submission is, he was just optionally brought out there. Which, in my opinion, cannot be. It is a promotion to you, to the post of court officer.
yes.
It may be written out there that it is subject to reversion and all, but reversion can only be by way of a penalty.
Yes.
So you have been promoted for all purposes there. But whatever happens is that you have to be, how do you gel both? The only way is to have a combined seniority list. This is what the judgment is. That is the only way.
The
You
offense
want,
seniority list
you,
which is-
Mr.
What
Mr.
I have not understood.
Huh?
That what I have not understood, just I would like to know from your lordship, that if that open seniority list is includes, which are the posts that will include in this list? Is AOJ, court officer, protocol officer, all these three,
All, everybody.
everybody?
Everybody will, that will be the combined seniority.
Yes.
list. So therefore, on the basis of combined seniority list, they will go into. So thereby, what happens tomorrow when the court officer, today you may not get it out there, but tomorrow when more posts are there, you get a chance. But otherwise, it's a question of reversion,
Huh.
which cannot happen. So you may not get today, or you may have a right to get it if the first 5 does not get 60%. So this is the only way which I feel, and more particularly this judgment of 89. This only saves the way by which one can beat down something or the other. Otherwise, it's a very complicated. And with that, here also the same thing will happen with the AJ. Mr. Panging's client would obviously come in, taking into account he comes within 1:5. He will come in. But if I give for combined seniority in the SJ, the combined seniority has to be given. If I give it in the SJ, the combined seniority list, then in that regard, those people who have never been the SJ, he cannot become the court officer, assistant registrar. Because you have a problem to see and two D. Two B, two C and two D. You don't have two D. As of now, you don't have two D. We are concerned with two B and two C. Two B is private secretaries. Grade one stenographers, private secretary, grade one stenographers to the honorable judges and other grade one stenographers. Now, if they are there, there will be also a combined seniority list to be prepared. And without this combined seniority list, they cannot be. Isn't it, Mr.
Yes, yes, ma'am.
Yes, I can't hear you.
Am I audible, my lord?
Bit louder.
Am I audible, my lord?
Now you are.
Yes. As far as my case is concerned, my lord, because of there are only two AOJs and one SJ, I get it in anyway.
No, understood. If there are two AOJs and you are one,
Yes,
you get it.
yes. ma'am.
But if I have a combined seniority list, how are you affected? No.
If the private secretaries are brought in, my lord, I am not very sure. I'm not aware of the numbers as
No,
of
no.
now.
They have to be grade one.
Yes, that also I'm not very sure, my lord. Here, what is
They
there?
cannot be a grade two.
Yes,
Grade two
yes,
is outside.
yes. How
Class
many
two
grade
B,
one?
Grade one.
Grade one are here.
Class two B, grade one.
Two B is grade one only.
Yes. Grade one, my lord. Private secretaries, grade one stenographers.
The protocol officer is an ex-cadre. Now it has been gathered.
No, it's wrongly, in book, it is wrongly typed. It's anchored already. It's a
Protocol officer is
mistake.
assistant librarian, system, senior system officer. All these things people will be there. Now to be assistant librarian, and what is this senior personnel assistant? They are grade two. They are not grade one.
Senior prosecutor, assistant, the stenographer. Below the grade one. They are grade two, senior person. is grade.
Where is it? Other grade one stenographers. No. Whether senior personnel stenographer, personal assistant will be grade one.
No, they are grade two.
They are in class three.
They are in class three, yes.
Yes, three.
Where? Senior. So they will be grade three. So their people are out. And assistant accountant, your personal assistant, library assistant, accountant is where? PA, na? PA.
Senior judicial assistant, including account.
Senior judicial area, including account. So accountant is out.
Editor, paper book.
So he cannot come in here. So therefore, here the petitioner comes in the ownership one. He will come in. Taking into account now he is in group 2A, 2B, 2C. The others are not. Who are senior in SJ also, they cannot come in. The thing is like this. An SJ who is senior to him also. But if he is an SJ, he cannot come in.
Cannot come into combined list.
No, he may be in the combined list, but he cannot come in. But an AOJ who is an ASJ, was an HJ, he will come in, then his seniority, interstate seniority will be taken with the petition. This is the only way out.
Lordship is suggesting for two-tier thing, wow, one for the purpose of promotion.
So there will be a requirement that the HA also, who is otherwise senior to the petitioner in both the cases. Just for example, in this case, this person, Srimati Nang Homcha Chapak,
Yes,
this person
Yes.
was promoted and joined as a senior judicial assistant HA on 27/6/2016.
yes,
But although the petitioner herein of Mr. Panging's client joined HA in 2017, but by dint of his promotion to the post of court officer, he can apply for extenuation.
and my lord, if I may point out, Nang
Huh?
Hangcha, if I may point out, my lord,
Yes.
Nang Hangcha Chokap appeared for the post of court officer, but she did not get it.
He did not?
She was not promoted. She also applied. She appeared in the interview also.
Now she has been promoted to the post of?
No, my lord. She earlier, when I appeared for the post of court officer, my lord,
Ah.
Nang Hongcha Chakap also applied. She also appeared in the selection process, but she was not selected.
No, it's okay.
Uh,
But
just pointing
he
that out.
cannot because he
Yes.
comes within 3B.
Yes,
So
exactly, my
3B
lord. That's-
cannot go there.
Yes.
So this appears to be the only way out. Fine. It has been kita mau mulai dulu. Mulai dulu. First of all, 1989, supplementary 1 SSC, page 34. Taking a look. Yag din ito. So, I'm sending it to you. Give it to me. Huh? Other one is 1988. This matter will require some more brainstorming, so I'll make it clear. You get it there next.
Oblige.
Hearing complete, judgment reserved.
Oblige, your lord.
Huh?
Yeah. Definitely, yeah, ma'am.
Competition for the post of even SJ can compete for right.
No, the High Court has to be more serious on that. Cannot have a reversing once he's promoted.
Well, the lordship is making it saving, just I wanted to point out. Here are some observation minors of the Honorable Judges Committee taken up on administrative side. And these are being annexed by the High Court, by the High Court in their. But you may go into it, this is also maybe of help citing this issue.
How does it help? Does it help you?
My lord, it may throw some lights.
How?
Because the provisions of the Rule 7(4) that was amended in 2015, the Honorable Judges Committee said that it's not maintainable. But since the rule is there, they said that we cannot override it. Since the rule is there, but it says that rule is not maintainable because.
Why?
Because of the fact that once you have given promotion to someone, you cannot ask him his seniority to be maintained in the lower category if it is a substantial post. That in administrative side, of course, but it is a judges committee, that has been annexed.
No. Whatever may be, but then also I am putting the AOJ in the same pedestal. You see, the problem is what? The AOJ keeping the seniority in the AOJ cadre and court officer maintaining the seniority in the HJ cadre. Isn't it?
This is the problem.
Now the court officer says that look here, we are equivalent posts. So therefore, I should also have a seniority in the which cadre? Court officer?
No, then your lordship is calling from the lordship that we have to have a combined seniority list.
So therefore, the
all
only way out.
For the year.
So therefore, the only way out is put the AOJ seniority in the SJ, whatever may be, only for that AOJ cadre which they may have it. But for the purpose of promotion to the post of assistant registrar, will be the combined seniority. Yes.
then SJ also is a court officer. Just to specify him, there will be a combined gradation list of AOJ and SJs by whatever name we call it, for the purpose of promotion of JI.
No, there will
No,
be a
as if-
combined gradation of two A, two B.
And to
Yes.
see.
Two A is not there, na?
Whether for.
Two B and two C.
Yes.
Two P and two C, two D is not there. So two B and two C, there shall be a combined for the purpose of
Yes,
there.
yes.
That is what I'll say.
The essay will not come into this combined gradation list.
That is why SJ will not, but seniority has to be taken from the SJ. Somewhere to, you have to take it.
My lord, what my reservation, what I'm trying to list before Lord is.
I know what you are trying. You are trying to say that I have been appointed as court officer prior to these people
No,
being
for the-
in
for
a
the
AOC.
purpose of, if it is the combined seniority list for the purpose of posting to the assistant lister, then the combined seniority list be amongst the, or including the groups which is feeder cater for the assistant lister. The posts which are not feeder cater for the assistant lister, including them, there cannot be a combined seniority, because that post is not a feeder cater for the assistant. This is my subject. Lordship want to pass on directing that there should be combined seniority list from those which are from, forms part of the feeder category. Then fine. But essay, for no, the rules does not say the essay is a feeder category for the estate. The feeder category for the estate lister is 2B, 2C, three groups. Three groups, madam. If I,
The two D is not there. No two D.
2A, 2B and 2C.
The two A is not there.
No, it's there. 2AA, sorry. 2 double A.
Two double A is there.
Sorry, I'm sorry. I apologize. 2B,
Two
2C.
D is not there.
2B, 2C and 2.
Two D is not there. There's
2D
no
is
post.
deleted, sorry. Then
So
it
now
remains
you
2B
have
and
two
2C.
B and two C.
That is why I'm saying the parcels, the post which comes under these two categories, 2B and 2C, the combined list will be including of these two groups. In these two groups, SJ does not come.
No, SJ won't come in.
That is
No,
what-
therefore, but the seniority has to be from the level of the SJ. So that those persons who have been also appointed as an SJ and became an AOJ, then how do you take care of that? There are a lot of senior people.
that is there, but the rule says that the feeder category is this two category only, 2B and 2C. So anybody comes in these two groups, they will form part of the whole pool. Out of those pool, from that pool, either it is merit cum seniority or
So
seniority.
no,
cum merit.
you see, to be SJ, a person who is in SJ, however senior he is, who is still an SJ cannot come within the feeder category of extinguished.
That is what,
That is what my also
Yeah.
understanding is that. So that I'm going to put it.
yes.
Seniority, however, has to be maintained. How? You want your seniority, that is what appears, that you have come to a promotion as an court officer in 2016 or 17. These AOJs have come and become, who are the private respondents, have become AOJ recently in 2018-19. So therefore, your seniority has to be number one.
Yes, in the combined list.
Filing. That
Yes,
is what I am saying, you are saying.
Yes.
But that would be this court interfering with the rule 7.4, which this court cannot. So I have to read down to say that for this purpose, it has to have a combined seniority list vis-a-vis their seniority as they maintain in SJ. That is.
That is why rule 7 is under challenge. Rule 7.
Go to the division bench.
No, it is under challenge. It is already filed. It's pending there.
So let it be there. But this is how it has to be, because otherwise, a lot of people You see, I understand one thing. You knew about this thing, post was always an optional.
Yes,
And you went out there. You got appointed. But, and your appointment was also made it very clear that you will be reverted back. But in my opinion, whatever may be, it is a promotion.
Yes.
So
Reversion
if
is,
it is a promotion, therefore, you,
reversion is not.
reversion is not permissible, although there is a mention of it. Then order cannot be on the basis thereof. There cannot be a reversion to a feeder category.
And one more argument may be,
Yes.
until and unless they are not reverted back, they are holding the post of court officer or protocol officer, whatever. Be. They are holding a substantive. Till they are not reversed. Even if.
No. Don't make that submission. The question of reversion does not arise.
Yes, that is what, even if. I'm
Even
saying
if also does not arise. I would not argue, make that submission. If I was a lawyer, I would never make that submission, even if also. That you have to say that it cannot, unless it is a penalty.
Penalty.
Chalo.
Obliged.
my lord had asked me a query as regards the period whether I was show any document. So, my lord may kindly peruse page 40, my. This is a document issued on 23rd of September 2014, whereby the CGM Bongaigaon has engaged me as a manual worker until further orders. Thereafter, my lord, at a pay of rupees 6,000 per month. Thereafter, my lord may kindly peruse page 43. My wage was hiked from 6,000 to 6,500. This is dated 2nd of July 2015 by the same CGM Bongaigaon. Thereafter, my lord, at page 46, my monthly salary was increased to 9,000 at page 46, and my name is there, serial number 2. This is June 2018. Deep now.
But we are concerned from September 2000.
Because it says until further orders, my lord. The order dated 23rd September 2014 at page 40. In continuation of this office memo number so and so, Sri Kuldeep Nath is hereby re-engaged as manual worker with effect from 29/9/14 until further orders at the rate of rupees 6,000 per month on the condition that he may be terminated without showing any reasons thereof. So this is, I was engaged as a manual worker. This continued, my lord, till 2018, it continued, my lord. Then the government, my lord, the judicial department at page 47, it had given the approval for engagement of 2 casual employees, my lord. That is at page 47 on 4th January 2020. Page 47.
So till then it is not there.
I was working, my lord. Then, my lord, may kindly peruse page 48. This is dated 16th March 2020, my lord. In the interest of public service and smooth functioning of official works and
With effect from 4/1.
because my lord may kindly peruse this order, because the order dated 23rd September, it says until further orders. I was working as a until further orders as a manual worker, and it continued till 2019. I was, and from 2020 onwards, I was made an casual employee, my lord. My lord may kindly peruse page 48. Because it says, my lord, that I am discharged from my earlier allotted work. Page 48, in the interest of public service and smooth functioning of official work, and on the basis of the letter dated so and so of 4th January, that is the previous page, my lord, by the judicial department, my lord. Regarding sanction of engagement of 2 number of casual employees on the concurrence of finance SIU department in the office of the undersigned, Sri Kuldeep Nath is hereby discharged from his earlier allotted work, meaning thereby, my lord, I was working, my lord. Earlier allotted work and engaged as casual employee at rupees 9,000 per month in the office of the undersigned with effect from 4/1/2020 with a condition that he may be terminated at any time without
showing
Where,
any
where,
reason.
where discharge? 840,
48. He is hereby discharged from his earlier allotted works. I was working as a manual worker, my lord, and engaged as a casual employee.
Yes. So that's.
So my stand in the affidavit is clear, my lord. So far as from period from September 2018 to December 2019, there is no record with us regarding engagement. After that,
But what do you say about 6?
848,
41,
840.
51, 51.
No, this is a certificate only, my lord.
Till date.
True, my lord. It's a certificate given by the, under what circumstances this certificate has been given. But this affidavit, my instructions was based on record. The records they have said that.
But this letter also shows that he was been discharged only on 2000.
Yes, page 48. Yes, it says, but we had to stop the payment from September 2018 due to audit objection. The payment,
Where's the audit objection?
yes, audit objection I have annexed, my lord, page 64. Look, it's reply to the inspection report. And in the affidavit. And the relevant portion, my lord, will find page 65.
It does not say that there was no work.
No, it says that presently the payment of the manual workers of this office has been stopped. And
It is not from the finance department.
so this is a reply given by the Chief Judicial Magistrate to the Accountant General Audit, Senior Audit Officer.
It says presently the payment of manual workers of this office have been stopped. But it does not say that there was no engagement.
In the affidavit, my lord, our stand is that
No, your affidavit is there, but that affidavit is contrary to the records.
no, we specifically said, however, from the month of September 2018, the payment to the petitioner was stopped due to audit objection, and there is no record of rendering any service by the petitioner from September 2018 to December 2019.
Where is the audit objection?
The audit objection is not there, but
Then-
it's a reply to the audit objection. Perhaps the reference is the page 64. It's a reference. This reply has been filed pursuant to a letter that is 29/10/2018. Page 64.
What is what is AR to annexure to? Page 67,
Annexure 2 is a proposal.
where is the proposal?
It says financial approval regarding engagement of manual workers in the establishment of the undersigned. So it,
So that will also show, why haven't you enclosed the enclosure?
it provides that, further it is with reference to the subject cited above, I have the honor to inform you that due to shortage of staff, services of manual workers were felt indispensable for functioning of the court and office board. In the interest of public service, my learned predecessor at different times engaged some manual workers, and they have been working in the establishment of the underside on the basis of monthly wage, as mentioned against their names in separate sheet. But there is no financial approval of the state manual workers for their engagement. Presently, on online bill system, it is not possible to meet up their monthly wages. In this regard, my learned predecessor wrote by this office letters number 2 and 3 under reference seeking financial approval for the engagement of the said manual workers to pay their monthly wages on time. Further, it is to inform with honor that budget allotment under head of account 02 wages are received every year from the Honorable High Court from time to time, and payment of monthly wages of the said manual workers were made earlier regularly from the said budget allotment. Further,
Now you see, finally come to page 68.
68. Yes,
I am directed to convey the sanction of the governor for engagement of a man
yes,
subject to availability under the appropriate head of account in the current financial year 2019-20.
Yes.
19-20 will start from 1st of April 2019 to 31st of May, 31st of March.
yes.
So therefore, there is a sanction.
No, this was given to us on 4th of January.
Whatever may be, but there was a sanction.
What the responsible
Are you
state-
saying that you did not allow anybody to work? That is nowhere mentioned except in your affidavit.
My understanding is that, he has said from 18 September to December 19, there is no record regarding engagement. This came after 2020, my lord, they were engaged again. Those documents are part of the writ petition. In 2020, pursuant to this approval, budgetary approval, so they were engaged again. Those documents. Page 48 onwards. There is no problem in paying, but if there is no material that they have,
No, their material is there, except your statement in paragraph 12.
also found material.
There's some material, there is material. That document
language.
2020 makes it very clear, page 48.
Page 48. It is of 16 March 2020. The interest of public service, smooth functioning of official work on the basis of later dated so and so regarding sanction for engagement of numbers of casual employees of the concurrence of finance so and so department in the office of undersigned so and so is discharged from earlier allotted works and engaged as casual employee so and so of the undersigned with effect of 4/1/2022. At anything, discharge from earlier engagement. That will also be considering to be that they were continuing.
Fact, apparent, not only that, this letter at page 67 also makes it very clear that your predecessor, the predecessor of the chief judicial magistrate Mogaigaon have also been writing out there.
Letters were written, my lord. That we need person, those were written.
Letters are, there are two aspects. Whether they work. If they work, they have to get it.
Exactly, no doubt about
That. But the question is, from your own documents show that they have worked. Except paragraph 12 of your affidavit.
May I take specific instruction?
Specific instruction properly.
On
And if
what basis they
necessary,
have-
then we'll take it up with the finance. whether there was approval or not.
Yes.
Can you finance?
If there is,
minister
if there is a single document to show, or on what basis they have,
and you
given
get
this
the
instruction.
document properly enclosed, the enclosure to page 67.
I'll get the entire record filled, I'll verify personally and I'll assist.
Subject to ineligibility for the previous 2019. This covers the area part. So subject
That is what I'm saying.
what, whether the fund was available or not, because pursuant to this letter.
Maybe the sanction is there for that period. More particularly this one, that will be from 1st of April.
Part
20 there is there. So they come within that ambit, this sanction.
the part of the area.
Fine.
So they may not get that amount of 9,000. They will get only how much? 6,500.
6,000, 5,000 was already remaining from total to 2018, page 42.
So June,
It will be 9,000,
Page 46, they'll get 9,000.
will get 9,000.
they will re-engage their skill development.
9,000 into how many months? September to
1,44,000.
November. But Mr. S, how the living council appearing on the HK does, so here will be High Court and here will be up Finance Department. Mr. S, how the living council subject, taking into account that the has now been already discharged, he would limit his release to tick number A, which pertains to payment of area salary with effect from September 2018 to December 2019. Act for 4,000. He submitted that during this very period of which petitioner had performed his duty as per the instructions so issued as per his order of appointment. However, the salary has not been paid. Submitted that merely on the basis of some audit objection, payment has not been made. On the other hand, Mr. H. does the Learned Standing Council have submitted that there is no material that submitted on the basis of paragraph number 12 of the affidavit that there is no materials available that the petitioner was engaged from September 2008. Because as it may, this court have duly petition dated 19th of August 2021, issued by the Chief Judicial Magistrate Bongaigaon, wherein there is a categorical admission to the effect that the petitioner have been rendering his service from September 2013 till 2021. In addition to that, this court have also perused the communication dated, the order dated 16th of March 2020, wherein also the Chief Judicial Magistrate Bongaigaon categorically admits to the effect that the petitioner was in service, was working as a
Later on, I was working as a casual worker at that time.
was working
What
and
is the manual work?
was re-engaged as a casual employee at rupees 9,000. This note further takes note of page 47, annexus 16 to the petition, wherein it is also seen that there was a sanction granted for the period for the financial year 2019-20. The above documents, however, appears to be contradictory to paragraph number 12 of the affidavit. HK does shall obtain appropriate instruction and place before this court records, and more particularly the enclosure to page 67 of the affidavit to filed by the chief judicial magistrate. whose, Mr. B. Gogoi, appearing on behalf of the finance department, shall also place before this court the instructions as to whether there was any financial sanction, whether there was any financial sanction granted for the engagement of the casual employees in the chief judicial magistrate during this period. This matter again on 22nd of May 2025.
Macho.
26 at 2 p.m.
But this is a challenge order of injunction.
Yes, what we where is Mr. Nath? And the finance department? Yes. Yes. He does it without it. Yes, what has happened to the rules?
Well, as per the information given to
3 to 7.
the rules, the judicial department has received on 17th of April. The clarification which was sought for the legislature. They received
We have already replied.
on 17th of April, yes. And the present status is that they are in the process of sending the file to the for concurrence to the finance department. It will be shortly, it will go to the finance department for their,
How much? Whatever finance department asks, we have given you.
that's true. Ultimately, when the clarification is to the judicial department, they have to send it again to the finance.
Then
It is in the process, but after the concurrence, with the-
we have sent it to the finance.
it is in the process, it will go.
That means
Well, after we received the clarification on 17th, they are in the process of sending the file to. They said that it has not done, but shortly it will go to the finance. The process of take the process of. After the concurrence of the finance, they will do the further.
So, Gogo, you are paying for finance. Take it up with the finance for an early resolution of this. It is seen that on 11th of April 2025, the Guwahati High Court have already sent the communication to the Official Department of the Government of Assam as regards the draft Assam District Employee Service Rules and agreeing to the suggestions so given by the Finance Department. We agree to everything. Mr. Dina, in that regard, communication has been placed before this court, which is kept on record and marked with the letter Y. Mr. Dina, the learned counsel appearing on behalf of the Judicial Department of the Government of Assam submits that the State Department is in the process of sending it to the Finance Department for further approval
For their concurrence.
for their concurrent, which will be sent in a day or two. This matter again on 22nd of May 2020, these matters again on 22nd of May 2025. Mr. B. Gogoi appearing on behalf of the Finance Department shall apprise this court as to what is the status pursuant status. Anyway, Mr. B. Gogoi appearing on behalf of the Finance Department shall apprise this court as to what further steps have been taken by the Finance Department of the Government of Assam. Mr. The DNAT also shall place appropriate material as to whether the groups have been notified. Have been notified. This is the matter again on 29th of May. 29th.
He has been delivered. The document which is.
First, we need to do this, then we will consider what is the case of it. And then do some social service. Yes, Mr. Decker.
We are challenging an order of injunction over. The respondent initially filed the suit for specific performance of an agreement for sale.
Then,
Third, find that agreement at page 12.
who is in possession?
That is the contentious issue, my lord. I say I am in possession. They say they were put in possession as a caretaker, my lord. But the fact of the matter is that I have a mutation, my lord. And the agreement by which they are seeking, of which they are seeking specific performance, doesn't mention anything about possession. Now, the trial court did not really return a prima facie finding as to who is in possession, but granted the injunction. At one place, it was said that I should not dispossess him. On the other hand, it was also said that both parties shall maintain status quo. However, it did not record any finding as to who was currently in possession.
Read a plain.
All the lordship, the conduct nicely explained. That is the- yeah.
Read the plain.
Page
Yeah,
14.
better copy of the plain.
Page 14.
Page
14.
understood, but it is in such bad shape. Defend number one, since the date of the purchase of the land by her has delivered the possession of the land to the plaintiff as the caretaker, and thus the plaintiff is in possessing the land by intention of valuable. How did you pay this amount?
Yes.
Yes. That day I found one judgment of the Supreme Court, na?
Yes. Regarding.
If payment of
Right.
cash is
Yes.
been made,
Yes.
then immediately it has to be reported to the income tax department. Is the bounden duty of the court constitutional? Let us. It has been now sold to you.
Yes. The registered sale deeds had already been executed.
Now the injunction against whom?
Against all three, my lord, it says defendants, not
So
particular.
one is already there.
One is all.
Now 2 and 3. Now can there be an injunction granted against another person who have been transferred? Recently there is another judgment, na? Very recently. There cannot be an injunction granted against.
On the basis of an agreement in as against third party.
Ah,
Yes.
since that the judgment is there, there cannot be an injunction granted against the third party on the basis of an agreement for sale. I think 7 days back,
Yes,
7,
yes.
10.
I'll just. Just get a thought. So, correspondence RBNAMS versus B Punish.
Is the name?
The correspondence. I can give the civil appeal number is 5200.
What is the name? The name of the party?
The correspondence,
The correspondent.
or comma RBANMS, educational. RBANMS
Versus
versus B Gunashekar.
B.
Gunashekar.
UNA.
GUNESHKAR. It's I've got the citation 2025 SCC online SC 793.
T25.
SCC online SC 793.
95.
793.
Nashik. UNA.
15.2 onwards. That transaction beyond 2 lakhs is at para 18.
It is given, na? We refer it also to the. Now, his agreement is dated, is it a registered document?
No, no stamp duty, nothing. 10/10/2012.
So it is effective on the 17th morning.
Yes. 10/10/22.
Mr. He take a the learning council hearing of the hearing of present appeal. There is an appeal filed under Order 43, Rule 1R, the Code of Civil Procedure 1908, challenging an order dated 29/1/2025, passed by the learned civil judge Senior Division, Noida, in Mise case number 82/2024, arising out of title suit number 79/2024, by allowing the application under Order 39, Rule 1 and 2 of the Code of Civil Procedure 1908. Be seen that by the impugned order dated 29/1/2025, the learned tribunal, the learned court of the civil judge, Senior Division number 1, Senior Division Bunagam, that is the learned trial court, hereinafter referred to as the learned trial court, directed the appellants herein, who were the defendants, their men, agents, etc., from dispossessing the petitioner from the suit land till the disposal of the main suit, and further directed both the sides to maintain status quo in respect to the suit land. The question arises in the instant proceedings as to whether this court is required to interfere the said injunction order, which is an order passed in exercise of the, which is an order, which is a discretionary order passed in exercise of the equitable jurisdiction of the learned trial court. The law in that regard is well settled, that if the discretion so exercised by the court of the first instance it ought not to be interfered with, since such discretion suffers from perversity, unreasonableness, irrationality, and irrationality, and is contrary to the well-settled principles for grant of an injunction. Taking into account in the backdrop of the above parameters of the settled position of law, this court would like to deal with the facts which led to the filing of the instant appeal. The respondent herein as plaintiff filed a suit being titled suit number 79/2024 against the vendor of the appellants as well as the appellants. It is the case of the plaintiffs in the suit that a plot of land at measuring 3 bighas, a plot of measuring 3 bighas, which is more specifically described in Schedule A to the plaintiff, is the subject matter of the said suit. It is the case for the case of the plaintiff that the defendant number 1 is the owner of the said suit land. It was also mentioned that the defendant number 1, since the date of the purchase, permitted the plaintiff to remain in possession over the said suit land as a caretaker, and the plaintiff accordingly possess the said suit land by plantation of vegetables, orchards, and sometimes by cultivating jute cultivation. In the year 2022, the defendant number one expressed her willingness to transfer the said scheduled suit land. Under such circumstances, the plaintiff approached the defendant number one in the month of October 2022, and it was agreed to that the said land would be sold at a consideration of rupees 1 crore 16 lakhs. That is at the rate of rupees 42 lakhs per bigha. 1 crore 26 lakhs. Huh? It is the further case of the plaintiff that on 10/10/2022, an amount of rupees 13 lakhs was paid to the plaintiff, to the defendant number one, in presence of witnesses. And subsequently, after a period of 6 months, another did you pay the second installment also? I paid only 13 lakhs. Subsequently, the plaintiff further went to the defendant number one and offered another amount of rupees 13 lakhs as the second installment and requested the plaintiff, the defendant number one, to sign the application form for land sale permission and also to provide the necessary required documents for the purpose of application of the land sale document permission. The defendant number one replied that she would need the money in 8-9 months later. The plaintiff had reposed her faith trust on the defendant number one and returned home. Later on, in the month of September 2023, the defendant number 2 and 3, who are the appellants herein, had visited the suit land and forcefully asked the plaintiff to vacate the suit land. On inquiry being made, they came to learn that the entire suit land was transferred to the plaintiff, to the defendant numbers 2 and 3, by the defendant number 1, by the registered deed of sale dated 5/8/2023. 5/8/2023.
Yes.
Full stop. The plaintiff could obtain the certified copy of the sale deed on 6/7/2024. And thereupon filed the said suit. It is the case of the plaintiff that the plaintiff is still in possession of the suit land. And the plaintiff was threatened by the defendants, number 2, to dispossess the plaintiff. And it is under such circumstances the suit was filed seeking specific performance of the agreement dated 10/10/2022, as well as for declaration, as well as for cancellation of the sale deeds, of the two sale deeds, being deed numbers 1441/2023, dated, and sale deed number 1442/2023, both dated 5/8/2023, and for issuance of necessary precept. The petitioner also, the plaintiff also sought for a permanent injunction this against the defendants, their men, etc., not to disturb the peaceful possession of the plaintiff in respect to the suit land. Along with the said suit, the plaintiffs also filed an injunction application, which was registered and numbered as case number 82/2024. This court, for the sake of brevity, is not repeating the contents of the said application, taking into account that the contents of the said application is parameterial to the contents of the plaintiff. Except the facts, except the statements made to the effect as to how the plaintiff has a prima facie case, the balance of convenience is in favor of the plaintiff and the plaintiff would suffer irreparable loss, harm and injury.
Was circuit officer not to issue permission to another person.
That has been done, no? That is not a material fact for this purpose. No? It is further pertinent to mention that in the said injunction application, the petition, the plaintiff sought for a grant of temporary injunction, thereby to restrain the opposite parties not to enter into the suit land and not to disturb the peaceful possession of the petition of the plaintiff over for the ends of justice. What is the first order passed? Huh?
Yes, 73.
This is not the first order, no?
This order is at page 72.
And after what?
And interim was granted.
To the said affidavit in opposition, to the said injunction application, the appellants herein submitted their written statement, written objection. It was categorically mentioned in the said written objection where's the written objection of the yours?
Page 52.
Huh?
The same written objection was filed by both the parties. I have a copy. So, yeah. Party.
This is being filed by one. Who is one?
One is the original.
Now, where's yours?
One is also an appellate governor. 2 and 3, I have it. It's exactly verbatim.
But then also this is required. Now, you are the appellant. All are appellants.
My lord, we were not, the original owner was undergoing treatment at Negrims on that fateful day. That is one.
It is seen from the reports that the appellants herein have filed their written objection. In the said written objection, the appellants have the appellant number one had categorically denied of entering into the agreement for sale on 10/10/2022, isn't it? On the ground that he was at Shillong on the date on which the said purported agreement for sale dated 10/10/2022 was executed. Full stop. It was further mentioned that it was further denied that any amount of rupees 13 lakhs was received from the plaintiff by the appellant number one. It was, it was also stated that after taking the land sale permission, both the sale deeds dated bearing number 1441 and 1442 dated 5/8/2023 was executed by the appellant number one in favor of the appellant number two and three. And both the physical and symbolic possession was handed over to the appellant number two and three, being the rightful purchaser. Full stop. Where is it mentioned that you are in possession?
Page 44, if your worship sees.
Huh?
Page 44, my lord. My lord, has the objection or the objection? Objection, my lord, your lordship will see page 58. my lord.
That have been mentioned.
And at page 44 of the written statement, we have clearly said that we never handed over possession to the plaintiff. Page 47.
No, where is your written statement? Objection.
Page 59, right, again.
Show me yours. Why have you written? Please, appellant number one who has no title. So you say that he has a right. Kindly see page 44. So far as apprehension of being dispossession of the plaintiff from the suit land is concerned, the same is actuated with malice, and the defendant number two and three are the best persons to take possession over the served by virtue of the iman, as well as the rightful for the NEA.
Then page 45, beginning.
Yeah. Where?
I have said that physical and symbolic possession was handed over. 45 I have said that he was never taken.
Huh?
45 page
We are not handed over, not handing, we have not handed over the possession.
to plaintiff.
He was saying,
And
but
44 have said
has a right to take over possession.
the wordings are, but on the top it has already been said physical and symbolic possession was delivered to the defendant.
The learned trial court, on the basis of the evidence, on the basis of the materials and reports, asked the impugned order dated 29/1/2025. Thereby directing the opposite parties who are the appellants hearing their men, agents, etc. Thereby restraining the appellants, the opposite parties, their men, agents, the appellants hearing. Who are the appellants hearing their men, agents, etc. From dispossessing the petitioner from the suit land till the disposal of the main suit. Mr. B.T. Decker, the learned counsel appearing on behalf of the petitioner appellant submits that when that the learned trial court, without ascertaining as to who is in possession of the suit property, directed the defendant, the appellants, not to dispossess the plaintiff, in as much as the plaintiff, in as much as per him, the appellants are in possession of the suit land. He further submitted that the appellants, the plaintiff's right, plaintiff has no right to claim any right over the said suit land. Taking into account that the plaintiff even cannot claim rights under section 53A in view of the fact that the purported agreement for sale dated 1/10/2022 is not a registered document. He further referring to the purported agreement for sale dated 10/10/2022 stated, submitted, that the said agreement for sale also do not state that possession was handed over. The learned counsel for the petitioner further submitted, appellants further submitted that the plaintiff himself have stated that his possession was that of a caretaker. And as such, his possession, he had no independent right to remain in possession, even assuming the plaintiff was in possession. And as such, the learned trial court would not have granted the injunction. Per contra, Mr. So and so submitted. Yes, to make the submission.
So there is a break out of prima facie case now. So the golden principle has been categorically explained. First thing is prima facie case, the balance of confidence, irrevocable. Here the petitioner is in possession. And lordship and the excellent hearing, if one hand enters into an agreement to sell, other hand lordship he sells the land, whole land to the another person. Thereby, here is the appeal number 2 and 3 are trying to dispose of the petitioner, present lordship, the respondent. Because he will suffer in the whole loss lordship, because he has already paid to his lordship. So, lordship, till dispose of lordship, this injunction order is very much necessary. Otherwise, he will suffer in the court.
Did you apply for the permission? After, here it says, which the second party acknowledged who it is deed, and the first party will pay the remaining amount of price after obtaining the permission of the sale of the land, and the second party will execute. Why haven't you applied for permission?
The agreement. Yes, but the agreement. Oh, টকা গ্রহণ করিলে স্ত্রী অনুমতিপত্র উলিয়ার ছয় মাসের ভিতরত ওই প্রস্তাবিত ক্রেতার পক্ষে বা মূল্য আদায় দিলে রেজিস্ট্রি বিক্রি দলিল করি দিয়ার বাধ্যতা।
So for a period of 6 months.
Adjudication method before the lawsuit is subject, the suit has been admitted, both the sides were submitted their written objection clause. So in the meantime, if he will be, he is disposed, he'll suffer definitely irrevocable.
What right you have remaining?
For the initially lawsuit, he gave me the.
It was given as a caretaker at best.
Yes.
You were given as a caretaker, your possession is that of the dependent number one.
That he already.
Permissive. How can the caretaker have any more right? Isn't it the judgment of the Supreme Court in which one? Maria, and the earlier one, not the Maria. Maria is 2006, no? 2012. 2012, Maria is 2012 6 SCC. Isn't it?
5 SCC.
In Maria, there is another judgment which have been quoted extensively from paragraph number 79 onward, 2012 5 SCC. That is the case of permissive possession. It is also by Justice Dalby Bhandari. Anyways.
The thing is, here,
By contrast, the learned counsel appearing on behalf of the respondent had submitted that the learned trial court had applied all the three golden principles in granting of an injunction. He submitted that if the petitioner is dispossessed during the pendency of the suit proceedings, the petitioner would suffer irreparable loss to the injury. He therefore submitted that this is not the case wherein this court is required to interfere with the implement order. This court have given an anxious consideration to the above the respective submissions and have also taken into account the materials from the court. From the implement order, there is nothing on record to show. Implement order, there is nothing that the learned trial court have asserted who is actually in possession over the suit plan. Under such circumstances, at the time of granting of an injunction, the learned trial court at best would have passed an order directing both the parties to maintain status quo as regards the possession, but however, could not have directed the plaintiff, could not have directed the respondents, the defendants who claim to be already in possession from dispossessing the petition, the plaintiff. This court further takes note of that the this court further takes note of that for the purpose of grant of an injunction in a suit for specific performance, there is a requirement that the learned court grant of an injunction for the purpose of grant of an injunction to protect the possession of the possession of the person with whom the agreement of the proposed vending, there has to be a possession being handed over by the deed in question, and on the basis thereof, certain rights will accrue in terms with section 53A, subject to the same document being registered. However, in the instant case, there is no, the agreement, the purported agreement for sale dated 10/10/2022 is not a registered document. Considering the above, the document, considering the above, the said agreement for sale dated 10/10/2022 can at best be said or can say to be a document which will enable the plaintiff to get a decree for specific performance and nothing more. Considering the above, the question of granting of an injunction at this stage in favor of the plaintiff did not arise in respect to the possession. In that view of the matter, this court is of the opinion that the learned trial court have erred in law and of the opinion that the improved judgment of the judgment and order dated so and so passed in case number so and so suffers from is unreasonable, irrational, and also is contrary to the law laid down, contrary to the well-settled principles for grant of an injunction. Accordingly, the improved judgment order dated the order dated so and so is set aside. Thank you.
Item 9 and 10.
Department.
There's affidavit filed.
But I have received the instructions, affidavit, I cannot find it, within a day.
So it is equivalent.
It is equivalent. The notification, finance department notification, kindly see serial number 12.
Now also, you have also in that rules. Rules also, you want that the post of the accountant put at the same level. Now, what was the issue out here? Mr. Sharma, what was the issue? I forgot.
But last order, kindly take
Advertisement dated so inviting application for appointment to the head assistant relaxing for 10 years. Oh, yes, in some Dhemaji and all, they do allow it. And it is only in the chief judicial magistrate thing, this wrong thing has happened.
Yes.
Whereas the district judge out there, and this is all Udalguri business. Ah.
one has taken that it is equivalent, another has taken it is not equivalent. One instruction they have issued, they have a file activity. What instruction they have issued, they have a file activity and will get it punished. So far as Jayanta Vora is concerned, Milord, I have filed the affidavit. Fine.
Affidavit file. 234.
Yes.
Item number 10.
You are the district judge. You are challenging the district judge's order.
Accountant has been appointed. I'm taking a challenge.
UDA,
No, but so
head assistant. So a UDA can be a head assistant. But as you say the accountant cannot. And his case is a UDA should be, an accountant should also be an UDA.
in that case, the respondent said that no, these are not equivalent.
His
That
case.
is his case.
So, let me see the next up 4 case 28 might be. Because he was the petitioner of the Senior of 38 from then he is promoted to the accountant. So when he is promoted from LDP or LDP accountant, then 28 my notification or this happened in that.
No. Why the Guwahati High Court is not filing it? So you mean to say, Mr. Das, you want to allow his petition? The Bhattacharya petition? Because here are both sides of the coin.
I'm in a, you know, I'm pissed off from both sides. I hope my brother don't enjoy this. Because this is absolutely a contradiction. And it has happened because the post of accountant was not included either in the rules or there was no deliberation by any of the authorities that what will happen to the post of accountant. If created, it's fine. But what will happen to those persons? That how different, depicting authority has interpreted in a different manner. Because one interpretation is that in the 87 rules, there is no mention of accountant. So in item 9, the stand is that since there is no mention, so we have to go by whatever is there in the rule. But thereafter, the government has produced an instruction making them equivalent. So so my brother has the instructions today. I have the notification of the finance department is 31st May. Section order, the 2007 matter. Here, the post of accountant is based on the
Pay scale is same.
promotion order was posted from LD. From LD, promoted to accountant from LD, so it is equivalent.
So can a supervisory assistant also become can also become what is this post of head assistant? We are concerned with the post of which one?
By selection from among upper division assistant with at least 10 years of service as such to their credit, including supervisory assistant in any chief judicial magistrate establishment ministerial.
So a supervisory assistant will also
Yes.
like can become a head
Above
assistant.
head, including supervisory assistant in any chief judicial.
So therefore supervisory assistant will come in.
Yes.
Now,
Already there, it's already there in the rule, the supervisor.
now kindly see what Mr. Nath has brought in.
Yes.
So if you see this notification of creation of the accountant, this
Yes.
one. 11 is supervisory assistant.
Yes.
Same pay scale.
Yes.
12 is accountant.
Yes.
13 is Nazir.
Nazir.
Same. He can also become.
So Nazir may have different avenue of promotion. Nazir will also- Nazir promotion, I think avenue.
But if we go by the scale of pay with rate pay, which they are saying, then even a record keeper can also.
In we cannot go by this grade pay.
Therefore, it cannot be on that. So they have to, therefore, they being the government,
Yes.
they are
they have to
therefore
take
to
a call.
equate. We need to file an affidavit, proper affidavit. There's no equation out here.
So the conscious decision has to be taken by the government that we have created the post of
Those
accountant.
are the
We are
pay
making
scale
it
of
equivalent.
12 is equivalent. We are not concerned with pay scale, because what will happen, Mr. Nath,
Yes,
if
but
we
okay.
adopt that, and we come to 11, 12, 13, 14, and 15. All have the same pay scale with grade pay. Okay. Then tomorrow the Nazir will also become the head assistant. Even a record keeper will be the head assistant. So you have to equate, because that is your rules. Isn't it? And what does the High Court say? I'm not concerned with this district judge. What does the High Court say? Because you see, the problem arises with the government also.
Equivalence, perhaps we cannot take a specific.
No, you will create a problem. The government may very well say that we say that, okay, accountant is the UPA also. They may say. Then you will say that who are you? Who are you? You may say.
35.
We have 235. Isn't it?
In fact, if I just reiterate, prior to filing this affidavit in item number 9, I had to, I tried to have a, conversation with the Registrar General on this particular issue. That's how the filing of this affidavit got delayed. I wanted to clarify this to the registry also, that we need to take a call on this and accordingly advise the government in this regard. What we'll have to do with this, both these posts. But that somehow did not happen. May I just say one thing, can this be taken up after the other 10 series matter? Those copies, typists and computer typists.
That one.
Yes, because rule is also there involved.
But there it is okay. How do you take care of these promotions?
There also, in the rule also, this accountant has been included in the new rule. This accountant post has been included in the new rule. Earlier, it was not there. It has no connection. It will give some,
In fact, we gave that reply. You see that?
Yes.
11/4/2025.
yes,
And you see that.
accountant is there.
That document also shows that about the accountant should be put out there.
Exactly. So accountant has been placed. Now finally a question may come that what will happen to this selection because these are prior to coming of the rule. That also we take a call on that, if the rule comes. Because if UDA and accountant is made equivalent, then all will be in the zone of consideration. Both the petitioners will be in the zone of consideration. It has no connection with the computer tech. Computer tech is defined under 18 defined.
No, what they have done, the government has not come up with a clear cut affidavit. They are only going on the scale of pay.
So that they indicate that because
See the problem, the moment I say on that, it will have an impact on the record keeper. The record keeper will also try to be a head assistant.
in fact, after such a decision, the most required next thing is to amend the recruitment. In central government, whenever there is a either merger of post or merger of pay scale, immediately DOPT will issue within a month amendment to the recruitment. That is not happening here. That's why there's so many problems.
Then the High Court should pass issue administrative instructions.
Yes, that can be done.
Which the High Court
For
should
that,
do.
for that purpose, I wanted to have a discussion with the Registrar General that if required, we need to issue some notification after
Because
deliberation.
you see, both the requisitions are different. I'm more particularly like cross cases.
I cannot place any stand in item 10 below, to be very honest. Will be of no stand. That's why on the last petition also I expressed below. Perhaps I may not be required to file it. Please pardon me for that. But the thing is,
Don't find that we take it on the document of present on paper.
exactly. So
But here not necessarily you have filed one affidavit. But this is being filed by the district judge.
yes,
So we require the affidavit from the registrar. But then if we get the intention from what is the High Court thing.
may I just pray one thing? Also, will keep the matter some other day. In the meantime, I'll just have a meeting with the registrar and I'll try to.
And
discuss the
the
affidavit.
government, you have to file an affidavit. You have not filed the affidavit. You can't come up with this type of thing. File if it is equivalent or not, because this is what you have asked for also. Or the finance, whatever may be, they have asked for that. Now you have a personal department, I suppose. What department you have? HR? Oh. Personnel, no. So who is going to go for equivalence? Equivalence is to be given by you. What are you making authority? Finance is no business. Their finance is not involved. We are therefore saying, what will be the promotional avenue? Whether this post will come within the feeder cadre. You also filed the affidavit by the High Court. Because what is happening is, if your affidavit of the High Court is in tandem with their affidavit, I can pass on order, na?
I understand.
Then they cannot also, later on the High Court cannot jump on the 235.
No,
And they can also not say anything more. Thinking that they have the rule making power.
yes. ultimately rule has to be notified by them.
They are not going to do anything with the rule. They
Yes.
are not going to do, but not necessary in view of now the new rule will be coming. We are not on there, but here we have to take care of this.
Perhaps, I think, so far as I remember, in the new rule, perhaps this accountant is in the feeder cadre of head assistant. Perhaps,
This is
last development, so far as I remember, last provision record I have seen. So
I have that, you have that main thing. That really, he has given it to me
yes, so that will ultimately mitigate the issue
later on.
later on.
Yeah.
Yes. That, you don't know the accountant.
Statistics, so it is seen that pursuant to the order dated 23/2025, no affidavit has been filed by the Commissioner and Secretary to the Government of Assam Judicial Department. So, the DNAT has placed before me, before this court, an instruction issued by the joint LR and Joint Secretary to the Government of Assam Judicial Department. The said instructions were produced mentioned that on account of both the pay scale of the accountant and the UDA being same, do not specifically address the issue. Rather, it only states about the pay scale of the accountant is equivalent to the UDA. So, under such circumstances, this court had to raise a specific query upon Mr. Dinat that if the pay scale is considered to be the factor, then for the post of head assistant, the feeder category would be the supervisory assistant, accountant, Nazir, upper division assistant, as well as the record keeper, whose all of which post has the same pay, on the, have the same pay scale and the grade pay. Mr. Dean submits that he will obtain instructions and file the affidavit on the next date without fail. This is the matter of 29th of May for.
Yeah.
You want to file affidavit, nobody is asking not to file affidavit.
Also, earlier order that was 22/2020, there is a mistake, madam. In Kerala, your notice stated that the post of accountant was created on 4/11/2005, but it is not. It is in 31st March 2007, madam.
No. I'm saying for districts of Udalguri, Sirang and Baksa only, on so and so the 3 posts of year was created.
Yes, but it is in 31st March 2007, not in 4/11 or 2000.
I saw it somewhere.
Page 26.
Huh?
Page 24 of my UPT.
Yes, it is one, na? Permanent retention of the post of the area. I am directed to convey the sanction of the Governor of Assam to the permanent retention of the following posts in the 3 districts.
This is permanent retention.
Huh?
Page 24.
This court further takes note of the fact that in paragraph number 3 of the order dated 23/2025, that there was a mistake in mentioning the date of the creation of the 3 posts of accountant. The date mentioned at paragraph number 3 to be 4/11/2015 be read as 31st of March 2025. Okay.
Much okay. Any order is to be extended, right?